supplementary item number 55. And we have filed a connected petition on Friday, my lord. That may be called for, my lord, today at 2 p.m., my lord.
2 p.m. I don't know. If the list is over, then I'll not sit. Then you either bring it before.
Oh, my lord. No, we will bring it, my lord.
Lordship, I am appearing on behalf of Mr. P.
On
Sharma.
their request, my lord.
Yes, Lordship. Can it be on 2 p.m. Lordship? Because he is suffering from illness since yesterday.
We will take it up tomorrow. What is the problem? Tomorrow for motion?
Yes.
On the request of Mr. S.P. Das, Lanet, consent for the petitioner made with the consent of the other side, let this matter, item 55, be listed for motion again tomorrow.
Right.
That is with the date, along with WPC number.
WPC number 6384. But filing WPC number.
Along with
Filing WPC. I'll file it.
WPC filed under filing number
6384
6384
of 2025.
of 2025, which is stated to have been filed by
On
this
Friday, my lord.
petitioner on Friday date to date.
Oh, my lord.
Yes.
My pleasure, Lordship. With the consent of the other side, I'd like to mention item number 26 and 27, Lordship. In this matter, I have sent affidavit of opposition for vetting, Lordship. Kindly 1 week may be granted, Lordship.
26 and
26 and 27, Lordship.
you've taken the consent of the other side.
Lordship.
With the consent of the opposite party, Ms.
Z. Bora, Lordship.
G. Bora, Learned Standing Council, Agriculture Department, Assam, seeks posting of these matters again after 2 weeks so as to enable her to bring the counter affidavit on record, which has already been prepared and sent for waiting. In view of the request made by Ms. Bora, let the counter affidavit be filed within a week from today by serving advance copy upon the petitioner's counsel. Register to list the matters again after 2 weeks by tagging the affidavit with the records of the case.
Lordship, I have another pair. In item number 49 also, I have sent the affidavit for vetting, Lordship.
You have taken the consent of the other side.
Lordship. Other side is.
Ms. G. Voral and Standing Counsel for the Agriculture Department seeks posting of this matter again after 2 weeks so as to enable her to bring the counter affidavit on behalf of the department on record. Since the prayer is made with the consent of the other side, same stands allowed. This the matter accordingly.
May it please, my lord. My lord, item number 28, my lord. In this case, our grievance has been redressed by the respondents, my lord.
Item number?
28, my lord. It has become infractious, my lord.
Right, you're right. Mr. A. Chaudhary and counsel appearing for the writ petitioner submits that during the pendency of the writ petition, the grievance of the petitioners has been redressed by the authorities and therefore the writ petition has become infructuous. In taking note of the submission of Mr. Chaudhary, this writ petition stands disposed of as infructuous.
Obliged.
Item 31, my lord, some accumulation for the day. I appear for the petitioners, making a mention on behalf of Mr. A.R. Gogoi. I've taken consent from the other side.
With the consent of the opposite party, a prayer for adjournment has been made in this case on behalf of the writ petitioners, seeking posting of the matter again after 2 weeks. Prayer allowed, list accordingly.
May
Yes.
his lordship, in regard to item 13.13, my lord, where filed affidavit in reply on Friday, I pray that the court may be called for.
Yes,
May I please, your lordship, with the consent of others, beg to mention item number 43. Lordship, this matter may be taken up after 3 weeks. I have not received the instruction, lordship.
43.
43.
Yes,
Yes.
you once,
Also, didn't need to tell my lord what to do. Short date may be given, my lord, because this case leads to compensation appointment.
Ms. K. Devi, and counsel is present for the writ petitioner on the request of Mr. B. Chaudhary, learned SC-BTC. This matter is directed to be listed again after 3 weeks so as to enable the learned standing council BTC to obtain instruction.
Lordship, can it date may be fixed, otherwise case will won't be able to list.
On the request of Ms. A. Devi, registered to list this case again on 23rd of June, 2025 as a fixed item.
May I please, Lordship, with the consent of the opposite counsel, I beg to mention item number 33. Lordship, kindly adjourn the matter for the day. My senior youngest counsel is out of station.
The prayer of learned counsel for the petitioner, this matter stands adjourned for 3 weeks, list accordingly. Yes,
My lord, most of the grievances have been met, I believe. This is a case by a deputy marshal of the Assam Legislative Assembly. Some so-called noticeman, flimsy notice was given to him. He replied. Then nothing happened. Suddenly 2 years, he found that his increments were cut. Then he approached this honorable court. Then this honorable court passed an order, my lord, 9/4/2004, where they, my lord, submitted the authority without any proceeding no proceeding conducted. 9/4/2004 order, lordship may have a look in the order sheet. They passed an order, and I think they complied. They restored my increments. They restored my.
grievance has been met.
That is bad, but only the tail remains, tail of the grievance. Because of the cut of increments, there is some calculation on my lord deduction with respect to NPS. New pension scheme. Another deputy marshal appointed on the same day with me, her deduction were more, around 1,600, and my deduction is still 1,200. That way, my lord, I may be hampered. So the last time it was, lordship may have a look at page 24. 24/4 order.
Yes. Yes,
Now actually it is for him.
This,
Yes,
Lordship, with regard to the order date 24/4/24, we have obtained the instructions, copy of the.
If it is done, my lord, then it is. Yes, my lord.
so we'll close it then.
Yes, only thing it was not forwarded to me, therefore I don't know. If it is done, my lord, lordship may observe it and matter may be closed.
What Mr. S. Borwal and Senior Counsel appearing for it.
NR Sharma,
Mr. N. R. Sharma.
on behalf of Senior Counsel Ms. B. Bhuya. On behalf of Ms. B. Bhuya.
Ms. BBA is appearing for whom?
Lordship, respondent number 1 to 4.
Mr. So-and-so, Learned Counsel.
All the
for the respondent numbers 1 to 4 on behalf of Ms. B. Bhuya. And a senior counsel engaged in the matter, full stop. The grievance of the petitioner was pertinent to non-payment of arrear increment and consequent failure to make proportionate NPS contribution from the arrear increment pay, thus causing prejudice to the interest of the petitioner. Today, when the matter is called up, Mr. Sharma, learned counsel for the respondents, has produced a copy of the notification dated 25/2024, issued by the OSD Joint Secretary, Assam Legislative Assembly, a perusal of which goes to show that the grievance of the petitioner on both counts, as noted above, have already been redressed. Mr. Borboral and his senior counsel for the petitioner, on perusal of a copy of the communication dated 25/2024, has also agreed to the same. If that be so, nothing further survives
Put on record, my lord. Yes.
adjudication in this writ petition by retaining a copy of the communication dated 25/2024 in the record of this case. The writ petition stands closed by observing that necessary follow-up action as per the aforesaid notification be initiated as expeditiously as possible, if not already done.
Obliged.
Carry out the charge. Please, your Lordship. Lordship, I want to withdraw this writ petition.
You want to withdraw?
Yes, sir.
Why?
Lordship, he's thinking of some other avenues, towards the petitioner. And also this matter is of 2018, Lordship, the advertisement.
So Mr. D. Decker and counsel for the petitioner submits that he has instructions from his client to withdraw the writ petition so as to explore the possibilities of availing alternative legal remedy. Mr. S.S. Royal and his CGC appearing for the respondents does not have any objection to the same clear. In view of the above, the writ petition stands disposed of on withdrawal. Mr. B.P. Bodal and counsel for the petitioner peruse the statements made in the contempt petition alleging willful disobedience of the directions contained in the order dated 6/3/2024, passed in WPC number 1982 of 2023. The instant petition has been filed. Full stop. This is more than 1 year. You have come after 1 year.
But we have filed it.
Having regard to the limited nature of grievance of the petitioner and in view of the recent judgment rendered by the court, by the coordinate bench on 4/3/2025, I am of the opinion that the learned government advocate Assam ought to be given an opportunity to obtain preliminary instruction before issuing notice in this case. As such, Mr. J.K. Goswami, learned additional senior government advocate Assam, to obtain instruction and appraise this court on the next date fixed as to the steps, if any, taken by the department, by the government, stroke SNC, for compliance of the court's order. One copy of the contempt petition will be furnished to Mr. Goswami, registered to release this case again after 2 weeks by reflecting the name of Mr. J.K. Goswami, learned additional senior government advocate Assam in the court list. You tell us what has happened, there is a
Lordship.
direction.
May I please, your lordship? Your lordship, the arguing counsel, Mr. R. Bhuya, is on legs on some other court, your lordship. This matter can be taken up after some
No,
time.
why is the contempt case? What is your, you praise the matter.
Yes, your lordship, here, the petitioner, Mr. Baharul Islam, was working as a Panchayat Secretary, Sahib. Your lordship, if I may, Mr. R. Bhuya has arrived, your lordship.
Lordship, sincere apologies, if I may. Lordship, this matters with regards to an order of transfer that the petitioner was served with. And then he had subsequently challenged that particular transfer order before this Honorable High Court. And the Honorable Court was pleased to pass an order with regards to this matter on the 17th of March, Lordship. It is at Annex 2, if your Lordship would be so kind, page 10, Lordship.
Yes.
Lordship, subsequently, this particular order that this Honorable Court had passed was then conveyed to the respondents and contender number 1 by hand on the 19th of March. It was delivered to her on the 20th of March via post as well. And then subsequently, it was also delivered to the other contemptors, Lordship. Lordship, what happened after that was the petitioner was then called to the office via phone call, and contender number 2 then handed him this particular document wherein he was again asked to take a transfer order, and it was wrongfully done so, Lordship, because this Honorable Court had passed an order which stayed this particular transfer order that they have said is still in effect.
Yes.
Lordship, that is our case.
But
Lordship.
the stay is not there.
Lordship, it was granted, Lordship.
It was granted till 23/4.
Yes, Lordship.
On that day, you didn't ask for extension. Look at the record. There is no stay order as on date. You-
But Lordship,
No, no,
when
no,
this,
but, no, but you go through the record first. Hmm. Was the stay order extended? So we'll close the contempt file and move an IA. You understand what has happened?
Lordship,
Yes. Contempt cannot be maintained now. The order itself is gone.
uh, just Lordship, if I may, Lordship, the stay was granted on the 17th, Lordship. The order copy was supplied to them on the 20th, within the next 2 to 3 days. Lordship, even before the next date came up, even before the stay was not asked for or was not granted as continuance any further, Lordship, they had already given this next order that we have said is a contempt, Lordship. That is up there,
That's correct. But since the interim order is no longer there,
Lordship.
that aspect of the matter cannot be agitated now.
Okay.
That's
Right.
the law.
Right.
Because it is meaningless. They will say they're out of mistake, but now the order is gone. So you have to challenge that order.
Lordship.
We'll close it by giving you liberty.
Lordship.
All right, heard Mr. R. Bhuyan and counsel for the petitioner. This contempt case has been filed alleging willful disobedience of the order dated 17/3/2025 passed by this court in WPC number 1349 of the 2025. Mr. Bhuya submits that notwithstanding the interim order dated 17/3/2025 passed by this court, the respondents have issued fresh order of transfer,
Yes, Lordship.
uh, pertaining to the petitioner. Full stop. After a careful examination of the materials on record, I find that the interim order passed by this court on 17/3/2025 was made operational till the returnable date, that is 23/4/2025. However, on that day, that is on 23/4/2025, no further extension of the interim order was either prayed for or granted by this court. Under the circumstances, there is no interim order operating in this case as on date. If that be so, unless the subsequent transfer order is interdicted by this court, the question of alleging contempt of order of this court may not arise in the present circumstances. Full stop. At this stage, Mr. Bhuya seeks leave to file appropriate petition assailing the subsequent transfer orders. By granting leave to the petitioner, this contempt case, leave to the petitioner to avail appropriate legal remedy, this contempt case stands closed. You file a petition, we'll examine it and then
Yes, Lordship.
there you can take this stand.
Right.
But the contempt is gone.
Right. Much obliged, Lord.
Yes.
Plus the order was will find at page 9, my lord. The upper party is page 11, my lord.
It has not been reinstated.
Not.
Mr. Aicharu, counsel for the petitioner. Here is the statements made in the petition alleging willful disobedience of the directions contained in the order dated 3/10/2024 passed by this court in WPC number 4847 of 2024. This contempt case has been filed. I now have 8 weeks left by registered to the
This is your lordship. Your lordship, this petition is filed for non-compliance of the order dated 6/3/25. Your lordship, the order starts from page 16. Relevant and the operative part of the order starts from the page 19. The last 3 paragraphs, lordship.
All right. Your name, please?
J. Lotha, lordship.
Mr. J. Lothar, heard Mr. J. Lothar, I counsel for the petitioner, peruse the statements made in the petition alleging willful disobedience of the directions contained in the order dated 6/3/2025 passed by this court in WPC number 409/2024. The instant petition has been filed, Mr. Issue notice return of 8 weeks petitioner to take steps for service of notice upon the respondents by registered post fee ready within a week from today. You take steps.
Hello, Vice Chair.
Yeah, yeah. Milord, this matter pertains to, Milord, the appointment of the Gram Pradhan of the particular area, Milord. The post of Gram Pradhan, Milord, vacated on 1/6/2023 on account of the resignation of the earlier Gram Pradhan, Milord. But since then, Milord, no recruitment has been issued.
But how can you come to the court with that? What is your right? What will happen if a recruitment is issued?
PN.
How can the court compel them to issue advertisement?
Because, Milord, in fact, we submitted some presentation.
You
Milord, but
tell
that
me
has-
the legal principle based on which you are asserting your claim. If they are not filling up a post,
Right.
how can the court say that you fill up the post? Because Mr. So-and-so is before the court.
Right.
Show me that principle. A relief in the court of law has to be based on some legal principle.
My,
Otherwise, it will be a chaos.
my,
Show me that principle.
that will not actually,
How much time you want to? How much time you want to come and address the court? You are ready today?
no matter then,
But is this a writ petition criminal? Why have you written criminal in your synopsis? On the prayer, yes, what do you have to say, Mr. Goswami?
Lordship, no locus stint, Lordship, no locus stint.
It will be dismissed either today or day after tomorrow, same thing. When do you want it?
my lord.
Don't file these petitions. This is completely setting at naught the majesty of the court proceeding.
Then in that case, I'm allowed to withdraw.
Mr. A. Ali, Learned Counsel for the petitioner, seeks leave of this court to withdraw the writ petition with liberty for his client to pursue appropriate alternative remedy as may be permissible under the law. The prayer is not opposed by Mr. J.K. Goswami, Learned Additional Senior Government Advocate Assam, and Mr. S. Datta, Learned Standing Counsel for the Revenue Department, Assam. In view of the above and on the request of the petitioner's counsel, this writ petition stands disposed of on withdrawal with liberty as follows.
May I please, your lordship? My lord, this writ petition is filed by the petitioner challenging lordship his suspension order, which was not reviewed within 3 months of lordship, its was issued lordship. So lordship, after filing of this writ petition lordship, they are now taking time that they have completed the inquiry or something else. But my writ petition is only on that ground, lordship, that whether continuation of my suspension is legal or illegal, as per Ajay Kumar Chaudhary's judgment, lordship, as well as the Rakibuddin Ahmed judgment of this honorable.
My lord, in this case,
That was not never reviewed, lord.
Let him finish.
So that was never reviewed, lordship, admitted, lordship. So on last occasion, your lordship directed them whether that order was reviewed or not, that instruction is required to place. That
Yes, yes, Mr. Chakra.
my lord, in this case, my lord, inquiry has been completed. Second, show cause notice with inquiry report has been subject to him. He submitted reply also. Thereafter, authority going to pass an order, he again filed an additional one, give me a time, I will clarify something. That's why 30 May is the last date for him to supply. If within 30 May he given anything, my lord, they will consider, if otherwise, they will pass the order. That is the position. The data, but what Ajay said, Dr. Kama.
We can only issue notice. You tell me when to fix the case. The writ petition cannot be allowed. That you understand, na? With so many years of practice. We can only ask them to file affidavit bringing their standalone record. So think on the date when the notice will be made returnable. That's all. Apply your mind as a lawyer.
Yes, lordship,
What
but
is the point in pushing?
Yes,
This
Lordship.
matter cannot be decided in motion.
Yes, Lordship.
If not, then the only option is to issue notice or to dismiss. You won't like a matter to be dismissed today.
Yes, sir.
So notice has to be issued.
But,
The only question is returnable date when. That's all. Is it not? Then why are you going here and there?
Lordship.
Think like a lawyer. It will help the court and you also.
Yes, Lordship.
Yes.
But only, your Lordship may fix it on next month, Lordship.
Of course we'll fix it. There is no other order which can be
Sixth
passed.
or seventh.
No. Heard Mr. N.H. Barboy and counsel for the petitioner. Also heard Mr. T.C. Chutial and standing counsel. Here for the ACB.
Yes, my lord.
ACB appearing for the respondents. Full stop. The primary grievance of the petitioner is that the order of suspension dated 9/10/2023 issued by the authorities placing the petitioner under suspension had not been reviewed within the period of 90 days by following the due process of law. Full stop. Mr. T.C. Chutia and his counsel for the respondents on the other hand submits that the inquiry proceeding, the departmental inquiry initiated against the petitioner in this case has already been concluded, and but for a request made by the petitioner seeking time till 31/5/2025 to place some additional materials in response to the second show cause notice, the authorities have not been able to take a final decision in the matter. First of all, under such circumstances, Mr. Chutia seeks 2 weeks' time to file affidavit to place all relevant facts on record. Considering the nature of issues involved in this writ petition, the prayer of the learned departmental counsel stands allowed. Issue notice of motion returnable on 16/6/2025. Since Mr. Chutia has appeared and accepted notice for, therefore, this is ASAB or SEBA?
ASSEB, my lord. ASEB earlier, Assam State Electricity Board. Only S is here, double S.
Double S, Lord.
Assam State School Education Board.
আচ্ছা তো এইটো আসাম স্টেট স্কুল এডুকেশন বোর্ড করব ASSEB notice for both the respondents. No formal notice is required to be sent in this case. The 2 extra copies of the writ petition were furnished to Mr. Chuti within 3 days from today. The respondents to place their stand on record by filing affidavit on or before 12/6/2025 by serving advance copy upon the petitioner's counsel. Registered to list the matter again on 16/6/2025 by tagging the affidavit, if any, filed by the respondents with the record of the case. The prayer for interim relief shall be considered on the returnable date, subject to filing of affidavit by the respondents.
Obliged, obliged.
Lordship, in this case, affidavit that you have send it for vetting, Lordship. By tomorrow, I can file it, Lordship. Notice was issued, Lordship, earlier, Lordship.
My lord, may I very briefly explain the fact, my lord?
Sorry?
May I, my lord, very briefly explain the fact?
You argue, but tell me at the end of the day when to fix the date for filing affidavit.
Fine.
You argue?
Second
Why are you arguing? You want to argue, but tell me why do you want to argue?
Man, it is discussion of a lordship. My lord, my only grievance is that, my lord, the suspension was not reviewed within 90 days.
No, Mr. Das, do you think he is saying he'll file affidavit by tomorrow? And you think the court will now decide in your favor in motion stage today?
No, my lord.
Why don't you all use your brain as a lawyer?
My lord.
Why are you arguing matters which he give him advantage to him today? Huh?
My lord.
Think like lawyers. Don't be emotional.
Earlier occasion, my lord.
Earlier occasion what?
My lord, they have given the verbal instruction, my lord. My affidavit
All
was-
right, then you argue. You argue.
My lord, they may file.
Of course they will file, but what do you want to argue today?
My lord, only my humble submission is that, my lord, my order has been not reviewed. They have reviewed my suspension order after expiry of, my lord, 90 days, my lord. And thereafter, my lord, my lord, the committee has been appointed. My lord, inquiry officer was, my lord, appointed only after expiry of 3 months. As on day, my lord, there was, my lord.
So, Mr. Dar, I'm telling you,
My lord,
I'm saying this, once they file the affidavit, then the court will issue notice.
My lord, lordship is correct.
Why did you have this matter in motion stage?
Let them file the affidavit, man.
They'll file the affidavit, you will not get any order, then the court will issue notice, it will come up after 3 weeks. And this is how you are yourself delaying your matter.
My lord, correct.
Let me issue notice here.
My lord, can it be possible to fix it on motion?
Mr. B.K. Das, learned counsel for the petitioner is present. Mr. S. Bettal, learned standing counsel for the Revenue Department, Assam, seeks 2 days time to file the counter affidavit on behalf of the department. In view of the request made by Mr. Datta, office to list the matter for motion again in the next Monday date dealer as a fixed item by tagging the affidavit, if any, filed by the department. Mr. J.K. Goswami, learned additional senior government advocate, Assam, is present on behalf of respond numbers 4 and 5. You have for 1, 2, and 3.
1, 2, and 3.
Think like a lawyer
My
when you are before the court. Okay.
My lord, next occasion.
You have missed out today because of your inability to think this case is going to be delayed now. These matters can never be decided in motion.
Man.
So next date will be for issuance of notice.
Man.
So you are deferring it. You should have asked today itself that please issue notice. Before notice, they are not bound to give a stand.
Man.
Again, you are saying. Absolutely unthinkable.
May I please, Lord? My lord, last occasion, my lord, instruction was sought for my lord from the BTC, my lord.
Instruction. What instruction?
My lord, petition was, my lord, selected as a, my lord, Anganwadi helper, my
So
lord.
what is the request you have, prayer you have here? What do you want?
My lord, notice may be issued, my lord, in this case.
See, he has learnt it. The prayer you are asking for cannot be granted. Why these matters are fixed for instruction? Somebody's appointment is illegal, obtain instruction. What instruction? He will say, yes, it is illegal. And then the private party is not before the court. What is the point in instruction? Only if a notice is issued, they will be bound to come and respond. What instruction you are supposed to obtain?
My lord.
Huh?
Section awaited, my lord.
Should always be-
Further time may be allowed.
Please apply your mind as counsel. Otherwise, it's not going to help the system. Part Mr. A. Hussain and counsel for the writ petition. There is the statements made in the writ petition. The matter pertains to selection process initiated for filling up the post of Anganwadi helper in 186 number Sishubari AWC. Anganwadi helper, is it?
My lord.
Mr. The learned departmental counsel appearing for the state has prayed for some time to obtain instruction in the matter. Issue notice of motion returnable in 3 weeks since Mrs. Borwa, learned G. Assam has appeared and accepted notice for respond numbers. 2 and Mr.
P. Hazarika on behalf of SR Rava.
P.R. Decker.
And
And
on-
Mr. S.R. Rava.
For respondent 1, 3, 4, and 6.
1, 3,
4, 6,
Four.
and 7.
6 and 7, Mr. Miss S. Burwal and G. Assam for respond number. Why not 5?
One may be allowed.
2 Pojok S. Burwal, Bagini Butakini, Mr. S.R. Rava, report the Divoto. Service of notice is deemed to be completed. In this case, extra copy of the petition deposited numbers be furnished to the learned department counsel so as to enable him to obtain instruction. Facilitating expeditious disposal of the writ petition at this stage of admission hearing.
My lord, pendency shall not be barred on the part of the respondent.
Pendency shall not be a bar for the authorities to redress the grievance of the petitioner in accordance with law.
Acknowledgement.
Lordship, we seek, Lordship, 1 week's time, Lordship, to get our up-to-date instructions. By.
First of all, what is the matter about?
My lord, petition was issued by the general department from the area goods in the Kanpur district as well as the Bolgar district.
So is it a service matter?
No.
Then why this matter is before this?
That.
My lord,
They challenged the notification, my lord, probably
not
That's
related
right.
to service.
This bench is taking service matters.
service matters.
Why notification of villages? Huh?
Not this bench.
All right.
Appropriate benchmark.
after going through the writ petition, it is doubtful as to whether this matter pertains to civil bench 3. Registry to therefore examine and list this case again in the next week before the appropriate bench.
Deeply obliged.
The petitioner is the father of an autistic child. Both the petitioner and his wife, they work with the armed forces. And my lord, the petitioner has been transferred out while his wife has been retained at the present place of posting along with the autistic child. The child was born out of, my lord, the IVF process because they could not conceive earlier. The child is just 4 years. We need another 3 years for his treatment.
So there is a stay interim order here.
Yes,
So,
my lord.
Mr. Dev Chaudhary, I think last week only, in a matter similar of similar nature, this court has made an observation that it is not only the petitioner who is seeking relief in these matters, but even the sick people. That was a case, I think
The mother was.
suffering from Alzheimer, autism, something like that. No, sure. So the courts have to think that it is not the petitioner alone. If the affected person, no, it's a matter coming within the domain of Article 221 of the Constitution of India, and we'll have to examine these matters.
Lordship, he has filed his reply on Friday, Lordship. He has brought out a few points, including this. So may I take 2 weeks' time to have some instructions on that?
Surely, but please tell your clients.
Yes,
that
Lordship.
let there be a solution. If there is a solution, a convincing solution, no problem. The courts doesn't want to interfere with the transfer orders.
Lordship.
But the people are saying, my mother is suffering from Alzheimer's. I am the caregiver. If I am moved out, she will. These are matters the courts will have to deal
Yes,
with sensitivity.
Definitely.
What about the person who is voiceless? That person, the sick child, is the affected party.
Lordship.
And in a way, the child is also seeking relief before the court.
Yes, indirectly, yes.
If the parents are forcefully made to leave, then it is the child who will suffer. So is the child also not a petitioner before the court? In a way,
Yes, Lordship. Yes. Through the
court will have to think about that. And then immediately it brings a supervening issue of Article 21. Because it is a question of right to life, a dignified, decent,
Lordship.
fulfilling life of the person who is unwell. The child is not able to come to the court.
Lordship.
So we would request you to have a.
I will definitely.
If it is a frivolous case, or if there is a solution available, certainly the courts would like to.
We'll explore that, Lordship.
Yes, but it can't be that we don't care. Our force, it is a discipline force, we don't care. It should be very difficult to accept that kind of a. Your force is huge. 1 or 2 persons here and there will not bring down your force. We know it is a very robust force.
Lordship.
It's a very powerful organization. It's a big force which is doing a great work. But these are subtle issues which cannot be dealt with force. These issues cannot be dealt with force. It has to be dealt with sensitivity.
Yes, Lordship.
We want to see whether force and sensibility can go together. How much time do you want to explore that?
Lordship, if I, can it be on 16th, Lordship?
16th of June?
Yes, Lordship.
Yes. Then let us issue notice.
I think
Okay, all right. I heard Mr. R. Majumdar, I consult for the petitioner who submits that. Reply on behalf of the petitioner has been filed. Mr. RKD Chaudhary, learned CGC, appearing for the respondents in this case, is for time till 16/6/2025 to examine the issues more minutely and seek updated instruction before addressing the court. Prayer is allowed on the request of Mr. RKD Chaudhary, learned CGC, learned DSGY, CGC now DSGY. This matter is directed to be listed again on 16th of June 2025 as a fixed item. Interim order passed earlier to continue till then. So,
I'm obliged.
May I please, Your Lordship? See, what has happened here is that I preferred an appeal against the order of my removal from service, Lordship. I preferred it in the month of December, Lordship. Now 5 months have gone by, Your Lordship. Yet to be disposed of.
My lord, we have received one instruction from the department, my lord. In this, here the department is praying 3 weeks more time to examine the matter properly and to furnish proper paragraphs comments, my lord.
Where is the file? So then we'll dispose of with the direction to dispose of the appeal within 3 weeks, right? Appeal is still pending.
My lord.
Appeal is still pending. Take down. I heard Mr.
P. Khatoniar.
P. Khataniya and I counsel for the writ petitioner. Also heard Mr.
H. Burwa, my lord.
H. Borwell and a counsel appearing for the respondents.
All the respondents, my lord. All the respondents.
All the respondents. Full stop. The writ petitioner hearing was serving under the
Lordship, he was serving as Inspector of Taxes, Guwahati Unit D.
The writ petitioner hearing, while discharging his duty as Inspector of Taxes, Guwahati Unit dash capital D, was placed under suspension. He was placed under suspension, is it?
I was, yeah, there's a removal order, so I was
Under
removed.
suspension. Pursuant to his arrest in connection with SAB PS case number 59/2023, and thereafter a departmental proceeding was initiated against him pursuant thereto by order dated 14/11/2024. The petitioner was removed from service. Agreed by the order dated 14/11/2024, the petitioner had preferred a statutory appeal before the departmental authorities. The grievance of the petitioner is that despite the lapse of more than 6 months since the filing of the appeal, no steps have been taken for disposal of the same. Hence this writ petition. The order. Which is the order of removal from service dated 14/11/24.
Yes, Lordship, 14/11.
So he had filed an appeal on 11/12/2024. By order dated, next parent, by order dated 30/4/2025, the learned departmental counsel was asked to obtain instruction as to the status of the appeal preferred by the petitioner. Mr. Today, when the matter is called up, Mr. So-and-so learned counsel for the respondents has produced a copy of the written instruction dated at 21/5/2025, issued by the Deputy Secretary to the Government of Assam, Finance, Taxation, close Department, perusal of which goes to show that 4 weeks further time would be required by the departmental authorities to examine the matter. First up, Mr. So-and-so, counsel for the respondent has however not denied that the appeal preferred by the petitioner is still pending disposal before the appellate authority. In view of the above and as agreed to by learned counsel to both the sides, this writ petition stands disposed of by directing the respondents to consider the appeal preferred by the petitioner and dispose of the same by a reasoned order within 6 weeks from the date of receipt of a certified copy of this order, subject to proper cooperation being extended by the petitioner in that regard. Mr. A copy of the communication dated 21/5/2025 be written in the record.
What's up, man?
Obliged, madam.
May please Lordship. The matter pertains to my lord selection and appointment of Constable GD in Central Armed Police Forces, my lord. Petitioner participated. Initially, she was declared, my lord, unfit due to my lord high measurement, but subsequently, my lord, petitioner approached this honorable court and this honorable court
direct the petitioner to file an appeal. Petitioner file appeal, and accordingly, my lord, petitioner declared, my lord, qualified in the, my lord, head matter. But the final result of the petition has not been declared till date, my lord.
His lordship, petitioner's case was sending to the SSC directorate. It is pending for declare the final result. He is qualified otherwise. And some, that instruction I have not received. How many times will take? Kindly issue notice, lordship.
So you agree that the petitioner is qualified?
Yes, the CRPF, the nodal agency who conducted the DME and RME, they declared qualified. That instruction I have received, and after that,
All right, I have Mr. H.R. Ahmed, learned counsel for the lead petitioner. Also heard Mrs. Burwa, learned CGC, appearing for the respondents who submits on instruction obtained in terms of the order dated 5/5/2025 that as per the re-verification exercise conducted by the CRPF authorities, which
Yes,
is the
Lordship.
conducting agency, the lead petitioner has not only been found to have met the physical conditions pertaining to height, but she had also qualified in the selection process. Therefore, a final decision in the matter is awaited. On such ground, Ms. Borua's 6th posting of this matter again after 2 weeks so as to enable her to complete her instruction. Prayer allowed, office to list the matter for motion again after 2 weeks. You bring
Notice not issued, lordship.
notice, why should we issue notice? You are agreeing that she is qualified. You have to appoint her now. You have to appoint her. Obligement.
May I please, Your Lordship?
Yes.
This matter is relating to compassionate appointment. The case of the petitioner has.
All compassion of Assam government has dried up. So what to do? Compassion is gone.
My lord, so far notification is concerned. Lordship, the honorable, this honorable court, lordship, in coordinate bench already held that that notification may not be, lordship, applicable in this case. My lord, I have annex one order, lordship. Case, lordship, 61. And after that, lordship. Basically, lordship, paragraph 8.
Yes, what is the matter? You have the instructions.
No, lordship, in another case relating to the compassionate appointment, there some order has been passed, lordship, where it is mentioned that till 3, 4.
Your opinion, will issue notice today. I heard Mr. M. Khan, counsel for the lead petitioner. There is the statements made in the lead petition. The matter pertains to compassionate prayer for compassionate appointment. However, during the pendency of the claim of the petitioner, the government of Assam has issued OM dated 18/9/2024, imposing complete ban on appointment on compassionate ground. According to the petitioner, his case has to be considered. He holds the OM dated 18/9/2024 for the reasons stated in the petition. First up, you agree? You are agreeable to
No,
the order?
lordship,
Ms. S. Borwal and
after-
Assam prays for some time to obtain instruction and respond to the prayer made in the writ petition. As such, I know in 3 weeks since Ms. Borwal has appeared and accepted notice for respond numbers
1, 2, 3, 4, and 5.
1 to 5, and who's for and Ms. Gogoi, J. Gogoi, and the SC Water Resources Department for respond number 6 and 7. Service and notice deemed to be complete in this case. Extra copy of the writ petition, requisite numbers they furnished to the learned department council so as to enable them to obtain instruction.
Well, pursuant to the advertisement of the year 2000, my lord, petitioner got appointed 2005. Thereafter, as honorary Gavura. Thereafter, they continued up as honorary, my lord. Similar circumstances, my lord, all the groups, those are the selected person, my lord, filed one petition earlier, my lord. It has been disclosed up. But he, in this proceeding, last proceeding, he did not, my lord, participated. So, my lord, for similar order, my lord, already all of them, my lord, petitioners have been already.
Similar order only if there is consent, otherwise not possible in
Similar.
motion stage.
No, my lord, 108 lordship policy, earlier order.
Are you agreeing to that?
No.
Then we'll issue notice.
Oh, you should notice for that. Only that petitioners, only that order.
He was also belongs to that category.
Lord Mr. H. does not counsel for the petition. The statements made in the petition. The prayer of the petitioner is for washing and setting. The prayer of the writ petitioner in this petition is for quashing and setting aside the advertisement dated 24/2023, bracket annexure 17, and also for the issuance of a writ of mandamus directing the respondents to adjust him against a regular post of village head in the district of Walpara, Mr. T.C. Chutia, learned additional senior government advocate Assam, and Mr. J. Hendig, learned standing counsel Revenue Department Assam, please for some time to obtain instruction in the matter. Then I am 6 weeks. You are for whom, Mr. Chutia?
I am for 2, 3, and 4.
Since Mr. Hendig has appeared for respondent number 1 and Mr. T.C. Chutia for 2 to 4, service of notice deemed to be complete, extra copies, etc.
Obliged.
18, my lord, I have received instruction, my lord. Ultimately, what happened, my lord, petitioner was in a contextually appointed in a scheme that has been expired on June 2022. Thereafter, one post is advertised for appointment, my lord. Petitioner participated, and while the retained petitioner did not qualify. That is the case. We will file a affidavit, my lord.
Elected.
Huh?
18.
18.
Nobajyoti Bora.
Oh, it will be different.
My lord, this matter relates to suspension of the petitioner, my lord, while I am in service. Subsequently, my lord, I have, my lord, superannuated. Now, the validity of the suspension has already expired, my lord. Now, I am without any pensionary benefit, even provisional has also not been paid. In fact, my lord, notice is required, my lord, if my lord is satisfied, my lord.
Notice should have been issued on the last date.
My lord, it
They
has
have lost out.
only the instruction has been called for, my lord.
See, whatever is his instruction, this matter cannot be decided in motion. So you have to apply your mind. What is the point in somebody is dismissed from service, obtain instruction? What instruction is to obtain?
Notice.
A notice will go, they will file their pleadings and the court has to decide the matter. So this is also something.
Exactly.
Why motion stays completely delaying the matter unnecessarily. Mr. R. Goyal and counsel for the petition. Here is the averments made in the writ petition. The issue raised in the writ petition pertains to effect of an order of suspension which had allegedly lost its validity by operation of law, thus coming in the way of settlement of the pension of the petitioner pursuant to his retirement. First, Mr. T.C. Chutia, and additional senior government advocate Assam preparing for the state submits that he has received instructions and therefore he permitted 2 weeks time to file affidavit. In view of the above, issue notice of motion returnable on 25th of June 2025. Since Mr. Chutia has appeared and accepted notice for respond numbers 1, 2, 3,
5,
and 5 to 9.
9.
And Mr. R. Boro, counsel for the respond number 10. Who is for 4? 4. Acha, Mr. P. Nayak, and additional agree finance for respond number 4, and Mr. R. Boro for respond number 10. Service of notice deemed to be complete in this case. Extra copy of the writ petition requisite in numbers be furnished to the learned department council so as to enable them to obtain instruction. Since it is a case of a pensioner seeking early settlement of his pension, an attempt to be made to dispose of the writ petition at this stage of admission hearing, parties to come prepared accordingly. Yes.
Obliged.
This is regarding non-payment of certain components of VRS. Covert material, lordship, can you come to page 118?
Notice has to go.
No, it's a covered matter, your lordship. Kindly come to page 118.
Page?
118, 118. Your lordship. Similarly situated person.
Yes.
I have verified, lordship, it is. Maybe it
It's
is
covered.
Covered.
Lordship.
In fact, with all due respect, lordship, nothing is required to be changed.
I take down heard Mr. P. Varadkar, learning counsel for the writ petition. Also heard Mr. N. Upadhyay, learning standing counsel, Irrigation Department, Assam, appearing for the respond numbers.
Lordship, 3, 4, and 5, lordship. 3, 4, and 5.
3, 4, and 5. Mr. H. Chakravarti, learned G. Assam has appeared for respond numbers 1. Respond number 1 and Mr. P. Nayak, learned additional AG, finance, the government of Assam for respond number 2. Full stop. The petitioners herein are former employees of
Soil, lordship.
ASMNDC.
former employees of the now defunct Assam State Minor Irrigation Development Corporation Limited, bracket ASMIDC, bracket close. Full stop. The petitioners, along with other similarly situated employees, were given VRS benefits sanction-wide notification dated 13/5/2005. The grievance of the petitioner is that despite the notification issued by the government with the approval of the cabinet, they have been denied the benefit of house rent allowances, medical allowances, and city compensatory allowance. As such, this writ petition. Mr. Bharadwaj submits that the grievance of the petitioner is covered by the judgment and order dated 24/7/2023, passed by this court in WPC number
5836 of 22, page 110.
5836. 5836 of 2022, wherein similarly situated employees approaching this court have been granted relief. Full stop. Hence, and as such, a similar order be passed by this court in the present petition as well. Mr. Upadhyay, learned departmental counsel, on due verification of records and after obtaining instruction, submits that the case of the petitioners is covered by the judgment and order dated 24/7/2023, passed by this court. Full stop. It appears from the next paragraph, materials on record, that after taking note of grievance expressed by similarly situated petitioners, this court had passed order dated 24/7/2023 in WPC so-and-so. The operative part of the order is reproduced herein below for ready reference, page 120. Full stop. Having double tick to double tick. Having regard to the nature of grievance expressed in this petition, this court is of the opinion that the case of the petitioner is covered by the petitioners is covered by the said order. As such, this writ petition also stands disposed of by issuing a direction in the line of judgment and order dated so and so. Respondents to do the needful accordingly. Writ petition stands closed.
Published.
All right.
May break your lordship.
I'm online, lordship.
Lordship,
yes.
here we are agreed by the show-cause notice which was issued. Lordship, the issue here is the petitioner is a
Similar matters are pending.
Lordship, similar matters, the only difference is, Lordship, there is no criminal case pending against the petitioner herein. And in this case, Lordship, on the day of issuance of show-cause notice, 30/11/23, immediately on the next day, the inquiry officer and presenting officer were appointed, without even affording me an opportunity to reply. And there is no list of witnesses in the show-cause notice. On those two counts, in my humble submission,
So what are you challenging here?
Lordship, I am challenging the show-cause notice primarily, along with that, the proceedings before the commission. Even the
Show-cause notice dated
Lordship, that is 30/11/23. Your Lordship will find that at page 68.
30/11/2023.
23.
When did you receive
Same
it?
date, lordship.
Lordship, on the 30/11/23, this was received by me on 1st of December. On the same date, on 1st of December, they already appointed inquiry officer and presenting officer. That is at Lordship, page 79.
So what order are you seeking today?
Lordship, your Lordship may issue notice, but these departmental proceedings which have been initiated, that may be kept date till the next date, Lordship.
But why have you come after more than
Lordship.
December 2023?
Lordship, he has submitted this reply. Thereafter, on 10th of June, he had received the communication fixing the next hearing date on 11th of June. That will be immediately on the preceding date that order was received. Under these circumstances.
Yes, Mr. Kohli,
Lordship, I may suggest, Lordship may issue notice, we will file a reply. This can be kept separate to the rest of the batch because his facts are slightly different, and as an officer, I must assist to that.
notice on both main prayer and interim prayer.
Yes, Lordship, on both. I think that would be fair, Lordship. And give us sufficient time to respond.
Peruse the amendments made in the writ petition. In the present petition, the petitioner is primarily assailing the show cause notice dated 30/11/2023, based on which a departmental proceeding has been initiated against him. I peruse the grounds of challenge. Mr. N. Kohli, learned senior counsel, assisted by who's assisting you?
Mr. Ankit Roy and Miss Nimisha Menon.
Mr. Ankit Roy and Miss
Nimisha Menon.
Namkara Didi, appearing through RBC, has sought 4 weeks time to file reply. Issue notice returnable in 4 weeks. Since Mr. Ankit Roy and counsel has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. For finance, who is appearing?
Lordship, I'm appearing for finance and otherwise, but my colleagues in Guwahati are there, so they can be issued the notice, Lordship.
Required in this case, extra copy of the writ petition be furnished to the learned department counsel so as to enable them to obtain instruction and file affidavit. Heard on the prayer of interim relief, the said prayer will be considered on the returnable date.
Grateful, Lordship.
Lordship. Lordship, the petitioner retired from service as a warrant officer clerk, my lord, is deprived from the promotion to the rank of Naib Sudhar clerk.
Yes, now after you retired in 2011.
Yes, my lord. The
We
benefit,
dismiss it with cost.
my lord, the benefit of the.
No, nothing.
My lord, benefit has been.
After 13 years, you have come seeking
No,
promotional benefit during your service.
My lord, the benefit of
You argue will dismiss 10,000 only, not much.
My lord.
10,000.
My lord.
15?
My prayer before your lord.
You argue will pass an order.
The benefit of.
See, your client has retired from service in 2011.
My lord.
Now he has approached this court 13 years after his retirement,
My lord.
saying that go back to my service career
No, my
and
lord.
give me the benefit of a promotion which I should have got and pecuniary benefits. Please complete your argument. I'll dictate it.
My lord, the benefit of the 5th pay commission was carried out by the Assam Rifle in the year 2016, my lord. After that, my lord, my ACP and MACP benefit was fixed in the year 2019, my lord. And then after my next promotion was due in the year 2009 as per the implementation of the 5th pay commission.
Mr. V. Kumar, learned counsel for the petitioner, peruse the amendments made in the writ petition. The grievance of the petitioner pertains to erroneous fixation of his. What is your grievance?
Promotion of the Naib Sudhar clerk, my lord. Due to lacking of ACR, they have rejected my prayer, my.
But tell us 10,000 or 15,000, what would you prefer? You understand, now? These are all abuse of the process of court.
Then, my lord, take this matter on Friday, my lord. Mr. Pathak will.
On Friday, yes.
My lord.
But you have to tell us whether 10,000 or 15,000.
My lord.
After 13 years, you come and say that give me promotion for service from Naib Subedar to so-and-so.
My lord.
Because I was entitled to that. Sorry, you should have agitated your given.
On
For
Friday.
the request of Mr. Kumar, counsel for the petitioner, this matter stands next week, next Monday.
My
adjourned till so-and-so. Ms. B. Sharma and CGC is present on behalf of the state. Don't file this on behalf of the union. Don't file this kind of petitions. Yeah, you think that the court is sitting here, throw anything at the judges, they will work. But now we'll make money. This time onwards, we are going to extract money from the litigants. This is absolutely casual approach. So we'll impose cost next day. Come prepared. Yes. Divyal.
Make it, please.
Yes.
Lordship, this is regarding appointment of Gangura Lordship. Lordship, petitioner and respondent number 6, both had appeared in the interview for Gangura. Then in the year 2017, petitioner, respondent number 6 was selected, and thereafter the petitioner had filed an appeal before the commissioner. Then on appeal, the petitioner was allowed, and the respondent number 6 was removed only on medical grounds. He has been suffering from young Parkinson, so he can't do such type of things, Lordship. That is page, Lordship. Lordship may kindly go to the page number, Lordship, 53.
Yes. What is your grievance, Mr. Dharapullah?
Lordship,
What do
page
you want?
53, Lordship.
What are you seeking in this writ petition?
Yes, Lordship, I am seeking this initially now, Lordship, stay of the impugn order, because he was being removed on the ground of this young Parkinson, and then I have been working now, and now he had filed a review petition before the commissioner secretary, and on review, in spite of the medical report that he is not fit of this medical board review on review, this I was directed, the DC was directed to this remove me and to give him.
Where is the impugn order? Page?
Impugn order is, Lordship, page 50, Lordship, 50. Lordship, in the on the below, Lordship, Roman 1, last post.
No,
Page
there was
51.
there was a selection process.
Yes, Lordship.
You were also a part of that.
Yes, Lordship.
You were also selected.
Yes, Lordship.
Where is the select list?
Lordship, it was long back, Lordship. It was in the impugn order itself, Lordship. It was long back because after selection, he has made appeal, Lordship.
Were you selected?
Yes, Lordship.
Show me that.
Lordship. Page number 29, Lordship.
Page number 29.
Yes.
Yes.
In the middle, Lordship.
Yes.
I am Siradul Islam, and he was Akhtar Hussain. And Lordship, on the ground of this, he is not fit because in the qualification, qualification as well as the removal condition.
Please take your seat, learned counsel for the petitioner. There is the amendments made in the writ petition. The order dated. (15/5, 2025), passed by the Secretary to the Government of Assam, Revenue and Disaster Management Department. That is the response number. Disaster Management Department. Setting aside the earlier order dated 25/8/2021, issued by the Commissioner, Central Assam Division, Nagaon, directing appointment of the petitioner as Gao Pradhan of village Sonari, Kisam, and restoring the appointment of the response number 5 has been put under challenge. Restoring the appointment of response number 6 as Gao Pradhan has been put under challenge internally on the ground that by ignoring the concrete evidence available on record indicating that the response number 6 is suffering from Parkinson's disease, the review petition has been allowed by complete non-application of mine. Mr. S. Dattal, understanding counsel for the Revenue Department, Assam, and Mr. T.C. Chutia, and GS, additional senior government advocate, Assam, have both wait for some time to obtain instruction with me. NOM's 4 weeks. Since Mr. Datta has accepted notice for response numbers 1, 2,
1 and 2.
1, 2,
1 and 2, Lordship.
1 and 2. And Mr. T.C. Chutia, learned additional senior government advocate Assam for response numbers 3, 4, and 5. Service was noted upon the response numbers 1 to 5 is deemed to be complete in this case. Extra copies of the writ petition, requisite in numbers be furnished to the learned departmental counsel so as to enable them to obtain instruction. Petitioner takes steps for service of notice upon response number 5. 6. Heard on the prayer of interim relief having regard to the facts and circumstances of the case. It is hereby provided that operation of the impugned order dated 15/5/2025, bracket Annex Roman 8, bracket close, shall remain state till the returnable date. There are similar orders, not so.
That's right. That order has already been decided, Lordship. That he challenged the impugned order, Lordship, 18/9/24, Lordship. That has already been decided, Lordship.
Yes, you know, no, there are similar orders here last.
He has challenged the.
DLC Hailakandi. Take out, yes. Mr. H. Chakraborty, G. Assam, Ms. D. New York, Standing Council, Irrigation Department.
Lordship.
No. But this is disposal. Those matters.
No, Lordship, there's similar issue, Lordship, has already been decided. Lordship, he has kindly see the
Mr.
impugned order,
Chakraborty,
Lordship.
are you aware of orders passed by this court last Friday? Where is that order?
On Friday, Lordship.
Yes,
on Friday,
I know.
Lordship.
4-3, it was,
Lordship.
something was passed on
Lordship.
Friday. You take out this, dispose of.
Item number 24 is similar.
Item number?
24 also similar.
24
Lordship,
same.
I am appearing in 24. May I please, Lordship, one thing? Kindly come to page 48.
No, now the order is that the SLC will
Yes.
now, because these are pending
No,
matters.
yes, this matter, this before 4/4/25, here is an observation in that order, Lordship. Kindly look at page 48, Lordship.
Page?
Page 48, para 10, last line, para 10, last line. It is again made clear that this order considered applied by the concerned authorities. It is again made clear that this order cannot be used as a precedent for cases that are filed on 4/4/25 and thereafter. It shall only apply to cases that are pending before this court as on 3/4/25. And this case was filed on, that come for first today, Lordship.
It is not a precedent, but the court can still direct,
Yes, Lordship.
dispose of.
So much.
Your name, please?
Miss A. Begum.
Miss A. Begum. One is H. Chakraborty, one is S. Bora. None appears for the petitioner on call. Let the matter be listed again after 2 weeks. Why are you calling admission from supplementary list? What about these admissions? Huh? Well, don't do it. Well, last order to cancel it.
My lord, yeah, my lord, the petition is going to return on 31st, my lord.
Item number?
57 on.
Item 25, you call out.
I heard 50. I heard 57.
We cannot start with this right now.
I
first-
understand, my lord.
Yeah.
Yes. After some time, let the other matter.
Yes, after some time.
Item 29.
Yes.
By order dated 27/3/24, department was directed to file affidavit, but they have not filed affidavit today. But this Chaudhary was appeared.
Yes, who is appearing in this case? Nobody from the tax department. Mr. Nayak? Are you aware of this case? It seems the taxation department.
Taxation Lordship, Big Ogre is appearing. I'm informing him. Lordship.
We wait for a little bit. Can you inform him, please? Item 13. Yes.
Item 13. My lord, is a long pending case. My client, he is yet to receive the GPF benefit. Other benefits he already received. After intervention of this honorable court, he got his pension and the gratuity also, other benefits, but GPF, what has happened regarding the GPF, when he was regularized at the instance of this honorable court, they have stopped deduction of the GPF. Instead, they started deducting CPF with the objectives of allowing a pension that way, because specifically it was mentioned in the letter of regularization that he will not be entitled to the pension, but only when this honorable court interpreting the matter, he enjoyed the benefit of the pension.
Give me some time, Lordship, to take instruction in this case. Latest instruction.
What instruction? This 2018 matter?
I know, Lordship, but this matter has been listed many times before the Lwajima, Lordship. Anyway, Lordship.
It done heard Mr. So counsel for the Mr. G.R. Dev,
my lord,
counsel for the petitioner. The petitioner before this court is a retired government employee who is agreed due to the fact that even after clearing his other retirement dues, the department is yet to pay the GPF. The authorities are yet to release the GPF dues of the petitioner for no valid reason. Mr. N. Upadhyay, and standing counsel for irrigation department, submits that since this matter has been listed after a long lapse of time, he be granted 2 weeks time to obtain concrete instruction facilitating disposal of the writ petition. In view of the above and on the request of Mr. Upadhyay, let this matter be listed again on 18th of June 2025 as a fixed item.
Right.
So as to enable him to obtain instruction.
All right.
I am appearing for respondent 6.
None appears for the petitioner when the matter is called up. Mr. So-and-so, learned counsel is present for the respondent number 6. Since the petitioner's counsel is absent today, the matter stands adjourned for 4 weeks. Yes.
Obliged.
Lordship, in this matter, apart from other orders, there is the order dated 5/5/2025, wherein respondent government was directed to file affidavit positively by 2 weeks, Your Lordship.
Not
As
a-
of date, they have not filed their
For the
affidavit.
instruction received, Lordship, they have stated that case is pending before the finance department, Lordship, for their approval and views, Lordship. It is the instruction, Lordship. On 22/5, Lordship, I have received the instruction, Lordship.
Finance is also directed to file their affidavit, minor. Counsel appearing for the finance department.
No, but you have to file affidavit.
Lordship, we'll file, Lordship.
No, you should have filed by now. Who is for the finance? Finance. Mr. Nayak, these are matters which cannot be resolved without your stand.
Lordship, affidavit will. Lordship, in this case, so far as our instruction is concerned, Lordship, the Women and Child Development Department is the concerned authority. So this is
You
the
file your affidavit.
Lordship, I will file. Lordship.
We'll give them a cut-off last chance, failing which it will be struck off. Your right to file affidavit will be struck off. Third, Ms. B. Buyal and Senior Counsel assisted by Ms. So-and-so and Counsel appearing for the writ petitioners. In both these writ petitions, peruse the order dated 5/5/2025, the means of which the respondents were directed to file affidavit on or before the next date of listing. Mr. P. Nayak, Learned Addition, AG, Beckett Finance, Beckett Close, Government of Assam. Mr. A. Chakravarti, Learned G. Assam, appearing for the state. Ms. J. Gogoi, Learned Counsel for the respond numbers 5 and 6, and Mr. R. Boro, Learned Counsel for the respond numbers 7 are present. First up, a prayer has been made by the Learned Counsel for the Finance Department as well as the state of Assam, seeking 3 weeks further time as last opportunity to file affidavit. Although by order dated 5/5/2025, this court had directed the respondents to file affidavit on or before the next date fixed, yet considering the nature of issue involved in these proceedings, I am of the opinion that one last opportunity is required to be given to the respondents to file affidavit. These writ petitions are therefore directed to be listed again on 25th of June 2025.
Lordship, can it be,
Yes,
can it be in the second week, minor?
no. We'll give them 3 weeks time.
25th after, I may not be available. Before 28th,
Then let it be after the vacations.
is retired employee lordship, so I pay for a date now.
Uh,
After
What
15th,
you are doing is you are pushing the matter to September.
then
Because
July.
2 weeks they will
Then
not
July.
file it, the court will
Lordship,
give another.
reopening, may I?
Yes, reopening. List again on 15th of July,
15th, minor?
15th of July.
Minor.
The counter affidavit on behalf of the respondents shall positively be filed on or before 25 June 2025 by serving advance copy upon the petitioner's counsel, failing which no further opportunity will be granted for filing counter affidavit in this matter. Understood. List these cases again on 15th July 2025 by tagging the affidavits, if any, filed by the respondents.
Summarized. Item 36.
May I please, as your lordship? My lord, the matter relates to, my lord, is the pensionary benefit for my, my lord, I am the dependent daughter, my lord, of the, my lord, adopted daughter of the late, my mother, my lord. Now, my lord,
Sure.
for us,
Who is the main respondent here?
my lord, the
Lordship,
affidavit has been filed.
Lordship, the adoption has been disvalidated by the district judge. That order has not been challenged.
Adoption has been?
She approached the Court of Law additional district judge for getting the certificate, Lord, that the adoption was validated. Since
62.
it was not registered, Lordship, only notarized, and that only a photostat copy was produced. So the application was rejected. That order has not been challenged. And moreover, we paid 12 lakhs to her mother. She's the granddaughter. Her mother has got 12 lakhs
That
as
you
a
are
nominee.
stated.
As a
That
nominee.
Mother is
All
still alive.
benefits.
Mother is still alive.
Whether daughter's daughter can be adopted, that
My
is
lord,
also.
in fact, my lord, I had been adopted, my lord.
Mother is still alive.
Huh? Alive, my lord, alive.
Then in view of this stand, you have to make her a party here. There is no way the writ petition can proceed.
My lord. Huh? Lord, we can implement my mother also, if my lordship allows me, lord.
No, but if you don't, then we'll close the writ petition. It cannot proceed because they are saying we have already paid whatever.
That is correct, my lord. That we are not.
That we
denying.
cannot ascertain unless the person is before the.
Then, my lord, can be adjourned for a week, my lord. We'll take the appropriate instruction.
You can't do it within a week,
1
2 weeks.
2 weeks, my lord.
On the request of Mr. R. Bhuyal and council. This matter stands adjourned for 2 weeks so as to enable him to file appropriate application. Seeking imprisonment of private respondent in this case. It's a breach of property and a CGC is present for the respondents.
Obliged.
May it please your lordship. In this case, they are required to file the affidavit, your lordship. We receive an instruction, my lord, we will file affidavit.
Mr. Arsenal and the council is present for the petitioners on the request of Mr. T.C. Chutial and an additional senior government advocate also appearing for the state who submits that he has already received the instruction and shall file affidavit against in 2 weeks. This matter stands adjourned for 4 weeks so as to enable the learned government advocate Assam to file the affidavit by serving advance copy upon the petitioner's counsel. List this case again as a fixed item after 2 weeks, after 4 weeks.
Deeply obliged.
May I please, your lordship? My lord, your lordship, kindly see the earlier order, my lord.
Hmm.
Really, my lord. We are claiming, my lord,
What
arrears.
you are seeking?
We have
My lord.
received instruction.
My lord, the salary
received
from
instruction.
April 2000.
You received instruction. You want to file affidavit? Let him file instruction.
My lord,
Hard Mr. A.
short
Manapla,
date may
the
be
counsel
given,
for the petitioner.
A short date may be given.
Yes. Also on Mr. T.C. Chutial and additional senior government advocate Assam who submits that he has received the instruction and seeks 2 weeks time to file affidavit. Prayer is allowed. Let the matter be listed again after 3 weeks as fixed item by tagging the affidavit if any filed by the respondents.
Obliged.
Obliged.
May I please your lordship? Mr. Sharma is legs before another court. May I kindly pass over the matter for the time being.
What is this matter about?
Pension. I am retired in 2021. I have not received pension, my lordship.
You have retired from UCO Bank.
UCO Bank,
You retired in 2021.
2020.
Then why have you filed it in 2024?
No, I have filed in 2024 because I pleaded with the bank. Bank took time to settle. Then ultimately, in the year 2023, early 2020, late 2023, they have refused me to grant pension.
What is the ground? Why they have refused?
As, my lord, in bank, the pension was optional. In the year 2010, I submitted by option. There was a cost to be paid by me. That was also deducted by the bank. The bank has also transferred the amount to my pension fund. But later on all my salary slips, it was recorded that I am a pensioner. But after my retirement in 2021, for 2 years, they neither have given me the PF amount, nor they have given me pension. Then I continued to plead. Then ultimately, they've said that they have not received my pension option. That then I have no other option to come before the court.
Your lordship, as per our records, the writ petitioner is not the pension optee. And the only mistake that has been done, that is in our salary slip. That is in the salary slip on the top of the right-hand side, it has been mentioned that he is under the option of the pension. But in the same salary slip, the amount which we have deducted is only against the PF. Your lordship.
So this matter will require full length hearing.
Yes, your lordship.
Is it not?
And your lordship, on the last occasion, we had.
A pensioner and if he is entitled to, he should get an early answer. When?
My pension cost was also deducted.
When do you want this matter to be heard?
As soon as possible. I'm ready.
Agree on a non-miscellaneous day, we'll fix it. All right. Heard, Mr.
Manoj Rai.
Manoj?
Rai.
Manoj Garg. Right. Then counsel for the writ petitioner. Also heard Mr. M. Sharma, learned standing counsel, UCO Bank, appearing for the respond numbers.
Yes, your lordship, for UCO Bank, your lordship, so it is
What
1,
is the
2, 3, 4,
respondent
5,
number?
6. 1, 2, 3, 4, 5, your lordship.
1, 2, 3, 4, 5. You are for?
6 is union.
Mr. S.K. Mehndi, learned CGC is present for the respond number 6. The matter pertains to claim of the petitioner for a payment of pension, which is the employer, former employer, that is the UP Bank, UCO Bank, has rejected. After hearing the preliminary arguments addressed by the parties, this court is of the opinion that the matter would call for full-length hearing. Since it is a case of a pensioner, a retired employee of the bank approaching the court by filing this writ petition, the matter would require expeditious disposal. As such, admit the writ petition since the respondents are already represented and pleadings have also been exchanged. The writ petition will be listed for final hearing on 17th of July 2025 as a fixed item. It is made clear that no request for adjournment on behalf of the respondent shall be entertained on the next date fixed. Parties to come prepared accordingly.
Please, Your Lordship. Your Lordship, in pursuance to last order, your Lordships had directed them to file reply on or before 21st. But now I have received the reply, your Lordship, just few minutes back.
I really apologize for the delay, lordship. We have filed it today, lordship.
This has become a habit. Nobody sticks on to the deadline. You are supposed to file affidavit by?
21st of
21.
May, your Lordship.
So you would like some time to?
Please, your Lordship, I need some time to go through because just few minutes back I received it.
All right. Your Miss?
Pallavi Avasthi.
All right. Miss Pallavi Avasthi and counsel for the petitioner is present and submits that in terms of the order dated 2/5/2025, instead of filing the affidavit on or before 21/5/2025, the respondent numbers 2 and 3 have filed their affidavit only this morning by serving copy upon her. Therefore, she be granted how much time?
2 weeks time.
2 weeks time to examine the same and file rejoinder if so required. Mr.
W. Raman on behalf of Mr. A. Sharma.
Mr. A. Sharma, our counsel is present for the respondent numbers 2 and 3 and does not have any objection if the prayer is allowed. Miss, who is for the CGC? Any CGC?
Gayan was
Mr.
Ms. A. Gayan was there.
Ms. A. Gayan, Learned CGC is present on behalf of the respondent number 1. On the request of Learned counsel for the parties, please let it go after vacation.
Your Lordships may fix any date because I have to come from Delhi. So
We'll
if your
fix it
Lordships-
immediately after vacation.
After vacation, any date may please. If possible, your
Can you
Lordship,
indicate a date?
end of June, if convenient to my lord.
End of June, you will come, but you will go back. Before vacation, this matter will not be hard. Can you indicate your preference? Do you want it on 21st?
18th of July, if convenient to my lords.
18th of July is a miscellaneous day.
I
All right, on the request of Ms. Avasthi and counsel for the petitioner.
Then whatever date suits to
21st?
21st. 21st would be my difficulty, your Lordships. May I have it on 23rd?
23rd.
Please.
Let this matter be listed again on
Or
20.
29th, your Lordships. 3rd or 29th, whatever suits to my lords. 23rd or 29th, any date, whatever is
3rd of
convenient to
July
you, lords.
2025 as a fixed item for admission hearing by taking affidavit stroke rejoinder affidavit filed by the parties with the record of this case. Yes, 23rd.
I'm so grateful. Item 41.
My lord, we have sanctioned provisional pension. We have deposited that amount which was sanctioned 5 lakh something. My lord, he has been paid his area pension also, area pension of 1 month, other process. But in his case, FRSR needs to be relaxed by the finance department. That file is pending with the department, my lords. Finance department is not a party.
You have filed your affidavit.
But one I had filed earlier, my lords.
But that does not indicate about my lord, my entire.
I have this.
Just a minute. Why don't you allow the court to interact with the counsel?
It will be this.
What, what, what is that you are saying? There is an order of 13.5. 13.5 is a fixed item for admission hearing by taking affidavit
Yes, 13.5, my lord, had indicated what steps we had taken. My lord,
You have
kept-
released the amount of 5,96,000.
Yes, released, man. And provisional pension has been sanctioned. 1 month. It to process it, na?
Provisional pension with 1 month's arrear pension.
Yes. 1 month area pension has been paid, provisional pension has been sanctioned, and other area part is under bill has been prepared, man. Will be deposited at the treasury very soon. And regarding his other claim matters, FRSR needs to be relaxed. The finance is under.
Yes, what do you have to say?
Lordship, I received a 1 month pension and 5,96,000.
That's what he's saying. What else
Nothing
you?
beyond that, man.
All right, heard
What
Mr.
I'm
Jaya
entitled
Bodhvia,
to.
yes,
What I'm entitled, my lord, I have typed out. If you look at permit me, I.
file it. Heard Mr. Jaya Bodhvia, learned counsel for the petitioner, also heard Mr. D. Gogoi, learned standing counsel, Forest Department, Assam, who is present on behalf of the respondent numbers 1 to 4, and Mr. D. Bhattacharjee, learned standing counsel, AG AME Assam, for respondent number 5. Mr. Sachindra Das, Joint Secretary, the Government of Assam, Environment and Forest Department, Assam, is also personally present before this court in terms of the order dated 13/5/2025, passed in this writ petition. Mr. Referring to the observations made by this court in the order dated 13/5/2025, Mr. Gogoi submits that an amount of rupees 5,96,446 has already been, along with 1 month's arrear pension, bracket provisional, bracket has already been deposited in the account of the petitioner on when 14/5.
No, my lords, it's 14.5, yes, man, 14.5.
On 14/5/2025. That apart, the provisional pension of the petitioner has also been sanctioned. First up, Mr. Gogoi submits that since finalizing the pension of the petitioner would require relaxation of certain terms and conditions of the FRSR, the matter is under active consideration by the Finance Department, and a decision in that regard will be taken at the earliest. First up, considering the submission made by the petitioner's counsel that his client is suffering from the dreaded disease cancer, and due to non-payment of his arrear salary, stroke, arrear pension, and other retirement dues, he has not been able to avail adequate medical treatment. This court had issued certain directions on 3/4/2025 and 13/5/2025. However, from the submissions made by the learned departmental counsel, it appears that some temporary relief has been granted to the petitioner. The said fact has also been confirmed by Mr. J. I. Borbhuya, learned counsel for the petitioner. Mr. Borbhuya, however, submits that that a direction be issued by this court to finalize the pension of the petitioner
Pension and arrear salary.
and release all his arrear dues at the earliest. The said prayer will be considered on the next date fixed, taking note of the request made by Mr. Gogoi. Let this writ petition be listed again on 15th of July 2025 as a fixed item, by which date the learned departmental counsel shall obtain updated instruction and appraise this court. The personal appearance of Mr. So-and-so stands dispensed with for now.
All right, man.
What else?
For the present. And until further orders, for the present and until further orders.
May it please your lordship, the petitioner is aggrieved by the order of termination dated 26/9/2024 issued by the respondent number 2, lordship, wherein the petitioner was terminated from service without following the due process of law.
We have not received a detailed instruction, my lord, so some more time
But
may be.
termination, you can't just go on taking time for
It
instance.
was terminated on
Then you restore him, you
uh,
will set aside the order temporarily.
September 2024.
We pass an interim order setting aside this termination. You take time. When you file affidavit, we'll hear.
2 weeks, my lord. See,
If he
he was
fails, then-
terminated on September 2024, my lord.
Oh, that's not enough.
So 2 weeks time may be allowed.
Last chance.
Last sir.
Last, heard Mr.
P board.
P. Borderline and counsel for the petitioner also heard Ms. A. Boral and standing counsel, NHM, appearing for the respondent who prays for is granted further 2 weeks time to obtain instruction and file affidavit. NHM is 2 and 3. Respondents 2 and 3. This is TC Chutil and an additional senior government advocate Assam is present on behalf of the respondent number 1. Register to list this matter again after 3 weeks by tagging affidavit, if any, filed by the respondents with the record of the case.
Last chance observation.
Huh?
Last chance observation.
It is made clear that no further time, no further opportunity will be granted for filing affidavit in this case.
Lordship. Oblige your lordship.
Item 44, no?
Item 44.
May it please your lordship, matter relates for arrears salary lordship. Lordship, extra copy has not been served on me, lordship. That's why I'm having a problem.
You are, your Miss?
J Ghosh,
Heard Miss J. Ghosh, and counsel for the petitioner, Miss
R Boral.
R. Boral. and
1, 2, 3
standing
and 4.
counsel, Standing counsel for which department?
Agriculture department, lordship.
Agriculture department, appearing for the respondent numbers 1, 2, and 3.
1, 2, 3 and 4, lordship.
1 to 4, submits them. Due to non-furnishing of extra copy of the writ petition, she could not obtain necessary instruction. Mr. R. Boro,
Six.
Learned counsel for the respondent. So Mr. T.C. Chutia, learned additional senior government advocate Assam, appearing for the respondent number 5, and Mr. R. Boro for respondent number 6, have also prayed for some time to obtain instruction and file affidavit. In view of the above, the petitioner's counsel to furnish extra copies of the writ petition, requisitive numbers, to the learned counsel for the respondents wherever necessary. And let this writ petition be listed immediately after the reopening of the summer vacation. In the meantime, parties to exchange pleadings.
Oblige.
Yes.
And the electrical matter, I didn't get that.
Yes. Who is appearing? What is the matter about?
Your lordship. Privilege of service, area salary and other benefit, your lordship. He was in opinions. So he was.
Let Mr. Bigo's name be shown in the cause list, huh? Because he has to appear. Heard Mr. S. Islam, learned counsel for the writ petitioner. None has appeared for the respondents. Considering the nature of issue involved in this writ petition, the court is of the opinion that the respondents' counsel, this writ petition must be heard in presence of the respondents' counsel. In view of the above, register to list the matter again after 3 weeks by reflecting the name of Mr. B. Gogoi and an additional AG Assam bracket taxation in the cause list.
Fix a date here. Fix a date here.
After 3 weeks.
May please your lordship. This writ petition challenging the impugned termination order that, page number 20.
In this case, my lord, although NHM has been shown in the cause list, my lord, but they have not made a party, my lord, NHM.
NHM is a party.
No, Lordship, if required, I will include the NRHM, but the present respondents is the appointing and terminating authority.
What is the matter about? What is the issue?
Matter about the petitioner was working as ASA under the SDM and HO, Nityananda. But by the impugned order, the petitioner has been terminated without giving prior notice and without giving.
Terminated when?
On 2022.
2000?
6/1/2022.
Where is the order?
Page number 21. Type copy 22, 20. Page number 21.
I am unable to hear you. Can you speak a little clearly? Where is the order of termination?
Page number 21.
Date of order is 6/1/2020.
Yes.
No, this is your application.
This is.
Where is the order of termination? It's not in page number 21.
Page number, this order communicated to the President of Rural Health Sanction and Nutrition Society. By this order, I have they terminated me. There is no separate termination order.
Who is for the health department here? Are you appearing?
No, my lord.
Where is the standing council health?
Upaman, no.
Yes.
Yes, what is, are you aware, Mr. Gogoi?
Yes,
My lord, actually, the Upomanu was appearing.
Sorry?
The Upomanu was appearing, was supposed to appear today, but.
So petitioner was Asha Karmi, her service has been terminated, new
Lots of-
person has been. What is happening really? If she was working,
Actually-
then why her service has been terminated?
Actually, my lord, probably it is the NHM authorities who is the appointing authority, my lord, of ASA workers. And they, NHM is not a party respondent, man. That's why, my
Right,
lord, the actual
the
case is not
director,
coming up.
mission director, NHM. After Mr. Borman, learned counsel for the petitioner, also heard Mr. B. Gogoi, learned additional AG for the state of Assam, appearing for the health department, who submits that since the petitioner was in employment under the NHM authority, the director of NHM is a necessary party to this proceeding. In view of the above, petitioner, the director of NHM is impleaded hearing, impleaded in this writ petition as respondent number 6. The petitioner's counsel to file amended cause title within 10 days from today. Issue notice to the newly impeded respondent number 6. Since Ms. A. Boral and standing counsel NHM has accepted notice on behalf of respondent number 6, no formal notice is required to be sent. The learned counsel for the NHM authorities to obtain instruction and file affidavit within 3 weeks from today. Let the matter be listed accordingly. You file your amended cost title,
Yes.
otherwise your matter will not progress.
Yes. Okay.
May I please, my lord, petitioner before your lordship is going to retire on 31st of this month, my lord. He was placed under suspension on 18 January, my lord, at page 37, but no review with the reason order has been passed. My lord. Though they filed affidavit does not reflect, my lord. Though show cause was issued to me, my lord, but they have not passed any reason order.
So you are appearing, Mr. Nayak? Now, what order? This has to be finally decided.
My lord, finally has to be decided, my lord, if it is not reviewed, my lord.
Then you have to wait. There are parted matters. First, I will finish it. Today it will not be possible. You have to fix another date. Bribery and illegal demand.
It is the allegation.
So what has happened is suspension has been reviewed
Yes, Lordship, extended, Lordship.
by order dated.
This Lordship 25/2025, Lord. Very recent.
Have you got a copy of this order?
No one.
Is it
If it is 25, my lord, it is beyond 90 days.
20th of May?
Yes, man. The suspension in the month of January.
See, before his retirement, suspension order need not be interfered with. There is no such law. Either you succeed or you fail.
Plus,
Whether it is done today or after 7 days or after 15 days or 1 month, that is another matter. So don't put pressure. Hey,
No, no, I'm
returning
not
that
saying,
first,
no,
decide it
not
today.
saying.
Those things will not work in
No,
this
my lord,
court.
I'm not saying also, my.
So what is to be done? If you want this, you want to file an affidavit on this? Because otherwise your case will be dismissed because they have extended.
I'll file it, my lord.
If you want to challenge, you file. And if you want to argue on the effect of suspension, then you have to point out at pleadings and then we'll consider.
That's it.
But that's when he's retiring, that's not going to help. People, if they actually indulged in misconduct, they will have to face the music. We'll
My
only
lord,
see
if
whether
it is so,
done.
my lord.
Huh?
If, my lord, there is a, my lord, prima facie, my lord, then otherwise. There is a just mere allegation, my lord. Complaint was given,
Prima facie is not required for departmental proceeding. Where is the law?
my lord.
But Mr. Jay, we are counsel for the petitioner who seeks 2 weeks time to file appropriate affidavit assailing the order dated 20/5/2025 issued by the Additional Commissioner GMC, Guwahati, extending the period of suspension of the petitioner for a further period of extending the period of suspension of the petitioner. Mr. P. Nayak, Learned Standing Council GMC is present. So no time limit is given, huh? Yeah.
Until further, right. Last but second paragraph.
All right, we'll consider, if he files appropriate readings, we'll consider. On the request of Mr. Borgia, let this matter be listed immediately after the additional affidavit is brought on record by the petitioner. What is the last time?
May it please, your lordship. Lordship, as per office note, 19th of 5/2025, I am supposed to file the affidavit with regard to justice service. Your lordship, grant me 2 weeks time to file the affidavit, your lordship.
The prayer of Mr. A. Das, Learned Counsel for the petitioner, 2 weeks further time is granted for filing affidavit on justice service as per order of this court. Mr. C. Sharma, Learned Counsel is present for
Dimas, Your Lordship. Dimas, respondent number 4.
Respondent number 4.
Respondent number 4.
Much obliged, your lordship.
Obviously.
None appears for the petitioner on call. Here is the Lojima Court order dated 25/2025, which goes to show that service of notice on respondent number 6 and 7 is complete, first of all. Mr. Mr. T.C. Thukiel, an additional senior government advocate Assam, is present on behalf of the some parties have been added in this case. I find there are only 5 respondents and the office note says 6 and 7. Hmm? The counsel for the departmental authorities are present. However, since the petitioner's counsel is absent today, this matter stands adjourned for 4 weeks.
In this case, as per the Lojima court order dated 2/5/2025, service upon the respondent number 8 is completed. Since as per the postal consignment report, it has been delivered. Respondent number 6 has filed affidavit.
Had Mr. S.D. Purkastal and counsel for the petitioner also had Mr. T.C. Thukiel and additional senior government advocate Assam, Mr. J. Hendrik, learned standing counsel for Thukiel for respondent numbers 1, 5 and 6. Mr. J. Hendrik, learned standing counsel Revenue Department Assam for respondent number 2. And Mr. P. Nayak, learned counsel for the Finance Department, appearing for respondent numbers 3 and 7. As well as Mr. S.K. Medhi, learned CDs, learned counsel appearing for the respondent number 4. And Mr. Purkastal submits that as per the Lojima Court order dated 02/05/2025, this matter is ready as regards service. Registry to verify and list the matter thereafter in the appropriate column.
Lordship, respondent number 6 has filed affidavit and we have filed a rejoinder also. I will reply also.
In the meantime, the remaining respondents, bracket, other than respondent number 6, bracket, may file counter affidavit if so advised.
That's
Madam, here matter pertains to Milord. The excess fuel from the family pension, Milord. The impin order passed. I am the 90 years old lady, Milord. Possible find the impin order at page 13, Milord, and except 2. And thereafter, immediately I made an application before the authority at page 18, Milord. Representation. I fake detailed grievance I have raised there, Milord. And 2023, this honorable court issued notice, but no affidavit filed case date, Milord. And this impin order is July. I filed this case September. Perhaps they have.
So you have an interim order.
Interim order till returnable date, despite.
Extended, had Mr. P.K. Dekal and counsel for the petitioner, none has appeared for the respondent.
Rafiq Mashi covered my case, my lord. Rafiq Mashi covered my lord.
You can't dispose it of in their absence.
So next week, my lord, can leave.
Yes. Since the respondents' counsel are absent today, let this matter be listed again after 2 weeks. Interim order passed earlier to continue.
May I appeal, Lordship? My lord, in this matter, I may be allowed some time to file a rejoinder to the affidavit filed by respondent number 6.
In the IA?
No, IA, there is already order to heart along with the petition. By order dated 24/2/2025.
So, let us see the writ petition. Mr. S.K. Devi, learned counsel for the petitioner. It will be in writ petition and counsel for the petitioner prays for and is granted. How much time?
My lord, 2 weeks.
2 weeks time to file rejoinder in response to the counter affidavit filed by the respondent number 6. Mr. You are Mr. K.K. Parasol, learned CGC is present for the respondent numbers 1 to 5. Whereas Mr. A. Chandran, learned senior government advocate, state of Arunachal Pradesh, has appeared for the respondent number 6. Let the matter be listed again along with the connected IA after 3 weeks.
And there is an interim order.
Interim order passed earlier to continue.
Nice.
Much obliged.
Lordship, I beg the apology, Lordship, I have filed this review application, Lordship. The
This is review petition,
Lordship,
taking review of which order?
Lordship, impugn order is page 74, Lordship.
What is wrong?
Lordship, in fact, Lordship, on that day, Lordship, I submitted the service book of the writ petitioner, Lordship. And as per service book, Lordship has passed the order. But it's recorded, Lordship, on instruction I have. Lordship, may I kindly see page 75, Lordship. Second paragraph.
Of January 2021.
Yes. Lordship, what happened thereafter, Lordship, the authorities have make an inquiry, Lordship, to the,
No, has it been reinstated?
not Lordship.
Then we will dismiss it on this ground. 7 days time was granted. You come after 3 years, 4 years.
Lordship may just modify one, Lordship, that
Yes.
the order was passed on the basis of the service book submitted by the standing council, Lordship. That will do, Lordship. Because, Lordship, the order on that day, Lordship, I just produced the service book of the petitioner, Lordship. And it was, as per the record in the date of birth in the service book, the Honorable Court was pleased to pass the order, Lordship. That modification, Lordship, perhaps
But that's
save
not-
my skin, Lordship.
That's not a ground of review. Then you challenge the order. Review cannot be done. We can't now pass a fresh order in a review. What is there is there. You are entitled to file a appeal and take every ground. That you are entitled to.
That is correct.
But in review, it is difficult. I heard Mr. Yanapadal and counsel for the petition. This review petition has been filed by the department seeking review of the order dated 7/1/2021. Whereby this court had issued a direction to permit the petitioner to join back service within 7 days from the date of receipt of a certified copy of this order. From the submissions made by Mr. Upadhyay, it appears that the department has not yet implemented the order dated 7/1/2021. Instead, after a lapse of nearly 3.5 years, the review petition has been filed. According to the learned departmental counsel, the observation pertaining to submission made on his behalf leading to the issuance of the judgment and order dated 7/1/2021 does not correctly reflect the proceedings of the court, and therefore such observations call for recalling. Such observations are required to be recalled by this court. Is that your grievance?
Lordship, Lordship, kindly see page 77, Lordship. The petitioner, Lordship, accepted the retirement, Lordship, and he has received all the pensionary benefits, Lordship. And after 2 years of his retirement, Lordship, he came with
You challenge the order.
Lordship,
After hearing the submission of learned counsel for the petitioner and on going to the records of the case, this court is of the opinion that there is no error apparent on the face of the record or any sufficient cause for this court to review the judgment and order dated 7/1/2021. The grounds urged by the learned counsel for the review petitioners at best can be taken up in an appeal, but the same cannot certainly be grounds to be considered by the court in a review petition. Consequently, the review petition is held to be devoid of any merit and the same is according to this.
May I please, Lordship? My lord, applicant before your lordship is the wife of the writ petitioner. Writ petitioner died after filing this writ petition. My lord, the petitioner applicant is interested to contest the matter, my lord. That is why.
This is for substitution.
My lord.
Yes. No objection, ma'am. Applicant is the wife of the original writ
My lord.
petitioner. Right. You please take down. Heard Mr. K.U. Ahmed, learned counsel appearing for the applicant. Also heard Mr. B. Sharma, learned
For 3 and 10.
appearing for the opposite party numbers 3 and 10 and Miss
Panchayat secondary board can you? Panchayat.
Sir.
You have not served copies upon the government.
My lord,
You have to serve copy, otherwise notice will have to be issued.
I'll serve my lord.
Opposite party number 3 and 7. You are for 3 and 7.
3 and 10, my lord.
3 and 10. However, it appears that copies of the IA have not been served upon the learned standing counsel appearing for the other opposite party. In view of the above, on the request of Mr. Ahmed, this matter be listed again after 10 days. In the meantime, copies of the IA be served upon.
I also not received.
I'll
I've
serve
just
my lord.
gone through the court
Give him
records.
the copy.
I'll serve, ma'am.
Yes. Copies of the IA to the respective counsel.
Obliged.
Much.
Lordship, that posted, office not shows that postal legal has.
Sorry?
Office not reflects that
Hmm.
the letter has been delivered to the addressee.
So we'll have to await service on respond number 5. Heard Mr. U.C. Rahul, learned counsel for the writ petitioner. Also heard Mr. A. Chakravarti, learned G. Assam appearing for the respond numbers
1, 3 and 4.
and
Lordship.
4. And Mr. P. Nayak, learned standing counsel finance department Assam for respond number 3. Mr. B. Chakravarti, learned counsel has appeared for the respond number 6. Await service report on respond number 5. Let the matter be listed again after 3 weeks.
Well, there is an order to file an affidavit by the other side, which a copy to us. Your lordship directed him to file an affidavit, which a copy to us, but we have not received a copy.
What happened? Where is the affidavit?
My lord, affidavit is prepared and sent for this for signature, my lord. Let it be after 1 week, my lord. Actually, the matter, I think for Kamrup district, no? You were saying. Matter to case, Kamrup district.
Kamrup district. Order to file an affidavit.
No. Actually, they are grievances, my lord. They are saying that they are working in the Kamrup district, they are not allowed.
We'll forget it. There
Yes,
is an
yes.
order of the court to file affidavit.
Yes, sir. I will find.
This will be the last chance, then we'll
Yes,
direct
yes.
personal
Yes,
appearance. I heard Mr. K. Sharma, learned counsel for the writ petitioner in both these petitions. Also heard Mr. T.C. Chutia, learned government advocate Assam, who submits that in terms of the order dated 29/4/2025 passed by this court, the affidavit has been prepared and the same has been sent for vetting. Therefore, Mr. Chutia seeks 2 weeks further time to bring the affidavit on record. In view of the request made by Mr. T.C. Chutia, Learned Addition Senior Government Advocate Assam, 2 weeks further time as last chance is given to the respondents to file the affidavit in terms of the order dated 29/4/2025 passed by this court, failing which this court will consider directing personal appearance of the concerned officer. The registry to accordingly list the matter again on 20th of June 26, 2025 for hearing as fixed item by tagging the affidavit, if any, filed by the departmental authorities. Yes.
Pending addition matter item 55.
You have made your submissions.
Yes, my lord. I have almost completed, my lord, subject to what my learned brother says. Because he wanted to say that those were not sanctioned posts and all. And in fact, in the advertisement itself, clause I showed to your lordships, wherein it was provided that the work employees who were on fixed pay can apply because these are sanctioned posts.
Where is Mr. Nayak?
Lord, he was here short while ago. Lord, I have asked my colleague to call him.
So their only point is this, that this 1 year must be regular service.
Yes, they
That's
say. In fact, my lord, I have gone through out of curiosity what the CCS pension rule provides. Because CCS pension rule, there is an interesting thing there. It provides that if his appointment is preceded by a medical examination, this 1 year business has got nothing to do.
And what has CCS pension rule got to do here?
No, it doesn't. My lord, I just out of curiosity, what is this 1 year is all about? I just go through it and I found that if it is preceded by medical examination, it has got 1 year has got no bearing. Even then also, there is a note in the CCS pension rule. It provides that this 1 year will include any service. Even if the service is less than 1 year, then also, my lord, it comes in the vis-a-vis the pension provisions. And here, the entire case is that continuous service. They are holding it to be a regular service, giving a different meaning to, and in that context, my lord, there is a judgment of the Honorable Apex Court also. And your lordship, in one occasion, wanted me to bring this issue vis-a-vis Article 14. But I have made some search and I got one judgment wherein not compassionate family pension, but pension vis-a-vis Article 14 has been discussed.
He's on legs, Lordship. He's just on his way, Mr. P. Nayak, Lordship. He's on legs in court number 10, Lordship.
What number?
Court number 10, Lordship. He's,
The part-heard matter?
yes, Lordship, we have informed him, Lordship. That-
The last item, what can be done? We'll take it up tomorrow then and finish it up. First item,
Lordship, yes.
first item of hearing. After tomorrow. But Mr. H.K. Das, Learned Counsel for the petitioner, a submission has been made on behalf of the respondents that Mr. P. Nayak, Learned Additional AG Finance, appearing for the state, is on legs in another matter, and therefore this depiction be taken up for further admission hearing tomorrow. There it comes.
I'm sorry, Lord.
Yes. So only one point rest we have already seen.
Yes, only one point, whether.
1 year must be regular service. That's the
I-
only point.
Yes,
Nothing else.
no, my submission will be whether this scheme, Lordship, is an isolated one or it has some connection with the rules also. It is subject to fulfilling the conditions in the rules.
Rules means pension rules.
Yes, Lord. Notification. Lordship is aware this person was appointed subsequent to 2005. That is, he is covered by the new pension scheme, Lordship. Now, this is the Lordship, this office memorandum dated 31 October 2017, Lordship. 31 October 2017. This is some clarification, Lordship. If Lordship comes to the third page, Lordship.
Third page of?
Page number 3 of the OM dated 31 October 2017. Page number 3, Lordship, serial number 2. Family pension for cases covering death of government servants while in service appointed on or after 1/2/2005. Family pension on provisional basis to the family of the state government employees appointed on or after 1/2/2005 and covered by the NPS, new defined contributory pension system, who have died in harness since 1/2/2005 shall be governed by the PNPG Department OM number so and so dated 14/1/2006. Second one, Lordship, we are concerned. However, the government servant appointed under new defined contributory pension system and died on or after 1/4/2017 shall be governed provisionally by the provisions as described under clause 1(3)(a) of this guideline and in terms of para 5.9 of Finance Establishment Department notification number so dated 14/9/2017. So, Lordship, if comes to serial number 1(3)(a), first page, Lordship, serial number 1. Next page, Lordship, may kindly say small Roman 3. The compassionate family pension sanction to the family of a government servant who died while in service on or after 1/4/2017 in lieu of compassionate appointment provided till 31/3/2017. A, this is relevant. The government in finance establishment A department by notification number so and so dated 14/9/2017 has come up with a scheme for compassionate family pension CFP in lieu of compassionate appointment for which there has been some changes in the admissibility of family pension to the family legal heir of a deceased government servant died in harness on or after 1/4/2017. As per provisions of the said scheme, where the employee dies before superannuation, after completing minimum 1 year of continuous service, the family pension equal to 100% of the last pay drawn by the deceased employee be paid to the family legal heir who have the eligibility to receive normal family pension as per ASP Rule 1969 as amended from time to time for a period up to the date of the deemed superannuation of the deceased employee, that is the date on which the employee would have superannuated had he been alive. The last pay drawn, this is not relevant, Lordship, I'm at the third line, Lordship. If he fulfills the conditions of getting a normal family pension, only then he will be eligible to get family pension, compassionate family pension under this scheme, Lordship. So that is the provision, Lordship. It's a subsequent clarification, Lordship, on the original notification.
Where is that clarification?
Third line, Lordship. Who have the eligibility, Lordship, kindly say small a, next paragraph. Who have the eligibility to receive normal family pension as per ASP Rules 1969 as amended from the time for a period up to the date of deemed superannuation. So my understanding is, Lordship, if he is eligible
All right.
So that is one,
What is
Lordship.
the next submission?
Next submission, Lordship, may kindly see that third page, Lordship. Two paragraphs were mentioned. One is clause 1(3)(a) and second one is 5.9 of that original notification, Lordship. That notification is at page 54 of the writ petition, Lordship.
Yes.
5.9. Page 55. Page 55, 5.9, Lordship. This will be applicable. This means this scheme will be applicable to all employees of state government, provincialized employees, and all others as eligible under Assam Services Pension Rules 1969 as amended from time to time, all state government employees under NPS category and all India services officers born on Assam cadre. So here also Lordship finds as eligible. If you are eligible in terms of pension rules, then this scheme.
NPS category is also there.
Yes, Lordship.
Then-
That is why that clarification is given. Lordship, may kindly see the second notification, paragraph page 3 again, Lordship. NPS has been given. So it says for in case of employees, NPS employees, Lordship, this is clause 1(3)(a) of this notification plus 5.9 of the original notification.
Yes, yes, yes.
That is one, Lordship. Secondly, Lordship, I have placed one document issued by the Accountant General ANE Assam Guwahati, Lordship. One copy has been furnished, Lordship.
Yes.
Third page, Lordship. The
Yes.
heading is Compassionate Family Pension. Admissible in the case of government servant dies in harness on or after 1/4/2017 at the rate of 100% of last pay drawn till the date of superannuation and thereafter at enhanced rate, that is 50% up to 67 years of age of deceased employee, and thereafter at normal rate, that is 30% as per eligible as per ASPR rules 1969 as amended from time to time. Second paragraph, Lordship. In the case of death while in service, the government servant should have completed a minimum period of 1 year of service to get family pension as per Rule 140 of the ASPR 1969 as amended from time to time. So this is the clarification issued by the Accountant General, Lordship. Third, Lordship, one more notification I have furnished, Lordship. This is 5th of May 2018, Lordship.
Compassionate family pension is not applicable to fixed play employee. But he is not a fixed play employee. He was, at least before he died, he was a regular employee. So this will have nothing to do.
Lordship, my only submission will be, Lordship, by placing these documents, Lordship, OMs, Lordship, I am only trying to convince your Lordship that this eligibility condition in the scheme is same so far as the pension rule is concerned. And without fulfilling the conditions in the pension rule, one cannot become eligible to get the benefit under the Compassionate Family Pension Scheme.
Mr. Nayak, I was going through the file.
Lordship.
All right, whatever you have argued, we'll consider. He has also argued. There was one area which caught the attention of the court,
Lordship.
which according to me could have a very, very significant bearing. Both of you have not addressed arguments, so I'll have to do my own homework. That is 5.4.
Of the scheme,
Clause
Lordship.
5.4 of the scheme at page 55.
Lordship.
Please read it once.
The last pay drawn for this purpose is the last basic pay in the pay band plus grade pay over and above the compassionate family pension. Compassion, that line to.
There is some, there is a, that's okay, ignore it.
Lordship.
This should have been one line.
Yes.
The next part, but they have broken it.
Above the compassionate family pensioner will get the applicable dearness allowance relief and other relief amount as admissible in the normal family pension.
So
Yes.
one thing is for sure, that unless the person who died in harness was drawing a regular pay scale, then he will not get it. Then there will be no compassionate family pension. That position is clarified by the 25th May 2018 also. A fixed pay employee will not get a regular pay scale. So he will not or she will not be entitled to any compassionate family pension. Only question here is whether the 1 year period should be 1 year as a regular employee or it would include 1 year period as temporary government servant also, provided on the date of death, he should be on regular pay scale. This question is significant because under the Assam Service Discipline and Appeal Rule,
Lordship.
government servant also includes a temporary servant. So petitioner's status initially, 2011, was at best of a temporary servant, government servant. But he was a government servant.
Lordship, one, so far as this disciplinary appeal rules is concerned, Lordship, in Assam, Lordship, even for a temporary employee, there is a requirement of post, Lordship. Post is temporary. The person is a temporary employee when the post is temporary. In his case, Lordship, no post is there.
Then how have they appointed him later on in water resources department?
That is why fixed, later on, Lordship, he was
On what basis?
subsequently, he was on a substantive post, Lordship.
Then that should have been pursuant to some recruitment process.
No.
Which recruitment process was adhered to?
Yes, Lordship. If Lordship comes to the recruitment order, appointment letter itself.
Mr. Naik, we will not come to anything. You tell us one thing, that he was substantively appointed against a post,
In
carrying a pay
2018.
scale,
Yes,
whatever it is.
yes.
Pursuant to which selection process was he appointed? Tell us that one.
Dear Lordship, in that appointment order, Lordship will kindly come to page 46, Lordship. Two notifications are mentioned there.
You tell us what, according to you, forget notification, we'll see it later on. You tell us that his appointment against a substantive post is pursuant to this selection.
Yes.
Tell us that, then
No-
we'll see.
No, as per this notification, Lordship, such recruitment was supposed to be made by following the
According
FRPM Act.
to you, what is it? You tell us, no, you are the council here. You are the BTC sending council also.
Lordship.
You have appointed someone substantively in a post, drawing a regular pay scale. So that has to be pursuant to some process. Is it
Lordship.
not?
That process.
Otherwise you are in.
Lord, yes, Lord, that I am accepting, that what I am accepting, Lordship. So far as this notification of 2/6/2018, by following which this recruitment order was issued, there it was clearly mentioned that such appointments shall be made by following the provisions of FRBM Act. That was not followed, Lordship.
So whose
That I
fault is
accept.
it? Whose fault is this? Whose fault is this?
The fault is there, Lordship, but at this stage, Lordship, I am not, even his first recruitment order, Lordship, appointment letter, no signature is there. Without that appointment, so we are not doing any inquiry, but I am on this notification of second notification only, Lordship, second OM of 31st of October 2017, Lordship. And
Yes.
as far as my understanding is concerned, Lordship, unless and until you become eligible for normal family pension, you are not eligible for compassionate family pension.
So who is eligible for normal family pension after 1 year of service? Give me an instance. Somebody,
Yes.
a government servant,
Yes, Lordship.
before NPS, normal family pension has nothing to do with NPS people.
Yes, Lordship.
It is the rules of 1969.
Yes,
So NPS was introduced in 1/1/2005, is it?
Lordship.
So let us assume that a person was appointed on 1/1/2004 and unfortunately he dies in 1/1/2005. Will he be entitled to pension under the rules? Show me that provision under which he would be. 1 year service, no pension.
Lordship, if it is less than 1 year, he will not be entitled.
But if he was, according to your own showing, if he was working for 1 year, his dependents will get family compassionate family pension.
Yes, Lordship.
Then are you not contradicting yourself?
No, that section 140, Lordship, rule 140, Lordship, it's a regular period of service, Lordship, regular service.
That's what you are saying, that whoever is entitled to pension under the pension rules will only get compassionate family pension under this scheme.
As per this OM of
Is that-
2018, yes, Lord.
So whatever as per, that is your matter of your research.
Lord.
That your stand.
Yes, Lordship.
Show me the provision under which 1 years of service gives pension under the pension rules. Where is the provision in the pension rules of
140, Lordship.
140. I have seen it, 140, 141 I have seen. 7 years it says.
No, it's 1 year. Family pension, 1 year.
Computation has to be for 7 years.
No, that is 142, Lordship. Normal family pension, it is 1 year, Lordship.
Anyway, I've seen it. I've understood what it. So, do you want this matter to be carried forward to the second half? There's a lot of things to argue. Anything much to add? What you have argued?
Lordship,
I understood your argument.
Lordship. Not just 1 year provision, Lordship.
Yes. You want to refer to 140?
Yes, Lordship.
Yes.
Except as otherwise provided in Rule 142, a family pension not exceeding the rate mentioned in Rule 141 will be admissible in case of death of an officer while in service or after retirement on or after 1st January 1964, if at the time of death the retired officer was in receipt of compensation, invalid, retiring, whatever pension, lots of superannuation. In case of death while in service, the government servants should have completed a minimum period of 1 year service, Lordship. This is provision for family pension, normal family pension, Lordship.
Yes. Yes, anything else? Let us see. I'll examine both of your arguments.
Lordship. Now, if it is so, Lordship, for to become eligible under the compassionate family pension scheme, you have to fulfill the conditions of pension scheme, Lordship. Then, Lordship, in that point, Lordship, I'd like to place one judgment, which narrates, in fact, what should be the nature of that 1 year period, Lordship.
All right, we'll come back at 2.
Lordship. Yes, Lordship. Lordship, first judgment is 2008-15 SCC 380. Copy the sir. Copy the sir.
What is the point, Mr. Nayak?
Lordship, here one small paragraph is there, Lordship, 2 small paragraphs, Lordship, in fact.
No, I'm asking, you show the paragraph, but I'm asking, what is the point?
Lordship, it states, Lordship, when that 1 year qualifying period comes into consideration, Lordship, it has to be a regular government servant.
This is in the context of this scheme.
Yes, Lordship.
Compassionate family.
Compassionate, this is family pension. That 1 year qualifying service, Lordship. Lordship, on last date, I choose not to place this judgment because your Lordship was on the point that this scheme is isolated from the rule, Lordship. There is a different scheme, rule is different. But Lordship, today I think.
Oh, Mr. Nayak, just be a little more clear and eloquent on this. You are saying that the compassionate family pension is nothing but an extension of the family pension granted under the Assam Service Pension Rules 1969. That is what
Not exactly that, Lordship. My point is that to be eligible under the compassionate families pension scheme, one has to be eligible as per the rules in the pension rules for normal family pension.
And that you say because of 5.9.
That is because of 5.9 and the subsequent office memorandum of 2018. That is a clarification of the original notification. The 31st of October 2017.
And that you say because as per the provision of said scheme, etc., who have the eligibility to receive normal family pension because of that.
Yes, Lord, under a family pension scheme. If one is not eligible to normal family pension, he is not eligible for compassionate family pension also.
So only those who are eligible to get family pension will be entitled to compassionate family pension,
Yes.
according to.
That is what it has been clarified, Lordship. In this OM of 2018 laws, 17 laws, 31st of October 2017.
So then that's the question I'm asking. Supposing a person who was appointed on say 1st of January 2015 on a regular pay scale, unfortunately dies on 1st of January 2017. Right. Or say he was appointed on 1st of January 2017 and dies on 1st of January 2019. So that person, even if he's a government servant, he will be covered by NPS.
Yes.
Correct.
Yes.
And if he's covered by NPS, there is no question of pension.
Yes, Lord.
And if that is so, there is no question of family pension.
No.
So that person's family will not be entitled to compassionate family pension.
No. Even though he is not entitled for pension, but his wife will be entitled to family pension if he, in the meantime, completed that 1 year qualifying period.
Where is that provision?
This is Lordship, this notification. Lordship, may kindly see this notification of 31st October 2017.
It was October 2017, yes.
Page 3, Lordship.
Hmm.
Page 3, serial number 2.
Hmm.
In serial number 2, Lordship, I am in the third paragraph, Lordship. However, the government servant appointed under new defined contributory pension system and died on after 1/4/2017 shall be governed provisionally by the provisions of as described under clause 1(3)(a) of this guideline and in terms of para 5.9 of Finance Establishment A Department's notification number so and so, that is 14/9/2017. 14/9/2017 is the original documents, Lordship. This is the clarification. Here, Lordship may kindly come to clause 1(3)(a). First page 1.
One.
Lordship may kindly say 1. Then Lordship may kindly come to the second page, serial Roman 3.
That you have shown already.
Yes, Lordship. So here, Lordship, in the third paragraph, A is there. Next paragraph, Lordship, that has been mentioned. One has to be eligible for normal family pension.
And how do you meet this argument that there was earlier a scheme for providing compassionate appointment? Compassionate appointment, anybody who dies in harness will have the right to apply for appointment on compassionate ground, subject to fulfillment of certain norms, should be of the employable age, the qualification has to be there, the vacancies must come within the 5% quota. Now, this family pension, compassionate family pension scheme has been introduced to replace the compassionate appointments.
Lordship.
In the sense that now, instead of giving appointments, the government is now giving monetary relief, right?
Lordship.
Now, all the arguments you are making, those were not relevant in the time of appointment on compassionate ground. At that time, whether he is entitled to pension or the NPS, or these are not relevant at all. Only thing is he should be a government servant. Then subsequent notifications came that he should have not less than 3 years of service remaining before death, etc. So there, even if a person is appointed, whether on permanent or temporary basis, and he dies in harness, then if he is the sole breadwinner in the family, then dependent family member can apply for compassionate appointment, right? That is how the scheme proceeded. Then you have introduced this CFP to replace it by providing for compassionate family pension. That compassionate family pension will continue under the scheme till the date on which the employee would have retired, had he survived till then. After that, the provisions of the pension rules will kick in. So, meaning thereby that a person who is not entitled to pension will also get compassionate family pension, but till that day when he would have retired from service. That is what your scheme, in the main scheme, the provisions say. You can't change it. After that, whether his family will get a pension, that will depend on if he is otherwise entitled to family pension. Not otherwise. Say a person dies, he gets compassionate family pension, but that may be applicable only till his regular date of retirement. After his retirement, the family may not get anything.
Probably that is the point, Lordship.
Listen.
Yes.
So family pension under the pension rules will kick in with effect from the date of his retirement. In case of a government servant entitled to family pension under the rules, may also be entitled separately. But those who do not come within these two categories, they will be entitled to benefit under the CFP of 2018, provided they fulfill the requirements of this scheme. Now, anybody who fills the requirement of these schemes will have to be given the pension. Anybody who does not fulfill cannot get benefit of the pension. Now, what is the requirement? One of the requirement is he should have completed 1 year of service. So anybody who has not completed 1 year of service will not get it. There cannot be any doubt about it. Minimum 1 year service is a must. Then how do you compute his compassionate family pension? That is 100% of the basic. That is also provided. So that means the employee must have a basic pay at the time of his death. Otherwise, he may not be covered by this scheme. What will happen in that case, that's not the subject matter of this case. In another matter, maybe your government authorities can issue another 5 notifications, we don't know. But only criteria must be 1 year, at least minimum 1 year of service, government service, and he must be drawing a regular pay scale at the time of his death. That is also because of interpretation of 5.4. It is not mentioned in 5.3. But if you put it together, this is the picture that is emerging. Now there is a provision in 5.9 which says that persons covered under pension rules, NPS, this scheme will apply. You are trying to say that this means this scheme will only apply to persons who are covered under this. That interpretation may not be possible, because what the 5.9 says that those who come under the provision of pension rules and NPS, in their case, this scheme will apply. If the idea was to make it exclusive to those categories, then the notification should have said it, that it will only apply to those in whose case these schemes apply. If you want to do it with prospective effect, issue a notification. There is nothing, nowhere there is anything mentioned which excludes this category of beneficiaries as is represented by the petitioner. All that you have shown does not exclude. Exclusion is less than 1 year exclude. That you have a clear notification. But not in permanent service, there is nothing to exclude. These are all looking for something here, looking for something here, there. And you are asking the court that pick up something from here and there, put it together, and adopt a negative approach.
My submission will be, Lordship, one notification of 2017, Lordship, September 2019. And these subsequent notifications are only extensions and clarifications of the original notification.
Correct, I have understood. Mr. Nayak, I appreciate your job is not easy. Don't for a minute think that the court does not appreciate your efforts.
Lordship.
You are trying your best to put across a point. It's not an easy easy brief. We are concerned of that.
Lordship.
But at the same time, if I don't interact with you, then you will not know where the matter is stuck up. That's why I'm interacting. It's not that
Yeah, of
the
course.
court is rejecting.
Obviously,
something like
I mean, Lordship, that is why I researched for this notification in such a subsequently
I
came. to me.
understand, but
Yes.
everything is fine. Only thing I will request you is keep your ears open. You receive what is coming from the court. Whether you agree, don't agree. Sometimes I find that you are closed. This is what I know, and I'm not going to listen to anything. That is not taking the debate forward. We are still in a debate.
Lordship.
And who knows, your arguments may be accepted by the court. Who knows? But if you stall the debate by being non-receptive to the queries of the court, then it does not proceed further. The matter ends there. The question I am repeatedly asking again and again and again is that show me a provision which has an exclusionary effect on the implementation of the scheme. That unless this person is in continuous regular appointment for more than 1 year, he or the family member will not be entitled to family pension. In response to that, you are trying to build up an argument by saying that there is something in the family, in the pension rules, something in the family pension under the pension rules, which says 1 year. So it says this here, it says that here. But the court has to be conscious that this is a scheme promulgated by the state to give benefit, immediate benefit to people who are in distress. So unless there is something which was beyond the intention of the state,
Lordship.
the court has to come up with a positive construction. It is not a legislation, but it is akin to a legislation. So you have to show me something which has got a clinching value to hold that because of this, unless a person has spent 1 year in regular service, he is out. Now, please.
Lordship.
I am even willing to accept your argument that if a person is continuously on fixed pay or as a temporary employee, it is possible that the scheme will not apply. That also I am willing. There is a clause, there is a notification which is there, you have shown,
Yes.
which has got a clause. Whether it is valid or not, that will be tested as and when somebody questions this. But as of now, this is not under challenge. I am accepting it. But the 1 year period should be entirely regular. Give me the material to hold that. So far, whatever you have argued, that does not canvass this point.
Yes. Now, so far as this notification of 25th May 2018 is concerned, Lordship just mentioned that serial number 3, the compassionate family pension scheme is not applicable to fixed pay employees. Now, if it is not applicable to fixed pay employees.
He is not a fixed pay employee.
No, Lordship, that is what I'm trying to make, Lordship. Whether that period of fixed pay can be counted.
Show me that. Everybody can come in a fixed pay and then go on to a regular pay.
Lordship.
You show me that entire period of 1 year should be regular.
Lordship, one thing probably I have conveyed that this scheme applies to only those persons who fulfills the conditions for normal family pension.
No, that will be rejected. Only is what you have added.
Yes, Lordship, may kindly see that notification once again, Lordship.
Yes.
I apologize, Lordship, but
Yes,
I have to rely upon this notification again and again, Lordship.
Please do it.
This 31st of October 2017.
Yes.
Second,
3.
yes, Roman 3, then
Yes.
Lordship A. I'm on the next paragraph.
Yes, please read it.
As per the provisions of the said scheme.
Scheme means the CFP.
Yes, original
Yes.
scheme. Where
SDM.
the employee dies before superannuation, after completing minimum 1 year of continuous service, the family pension equal to 100% of the last pay drawn by the deceased employee be paid to the family legal heir who have the eligibility to receive normal family pension as per ASP Rule 1969.
Continue.
For a period up to the date of deemed superannuation of the This is employee, that is the date on which the employee would have superannuated had he been alive. So that line only, Lordship, one line.
So if the interpretation you are trying to give,
Lordship.
then by adding this now, they are taking away the benefits conferred originally under the scheme notified in 2007.
Lordship, this is a clarification. In the original one, this provisional, and this is a provisional, Lordship, kindly see page 3. Page 3, serial number 2. Lordship, these persons, Lordship, who are covered by the new pension scheme, this benefit has been given provisionally. Second paragraph, Lordship, serial number 2. However, the government servant appointed under new defined contributory pension system and died on or after 1/4/2017 shall be governed provisionally by the provisions of described under clause 1(3)(a) of this
Is it
guideline.
based on some cabinet memorandum?
Yes, Lord.
Huh?
This is office memorandum. Lord.
No, cabinet memorandum. The scheme is prepared. on
It's
the
a
basis of
government
cabinet.
policy, Lordship. Cabinet took the decision, Lordship. In fact, Lordship, this scheme was discussed in the budget session of 2017-18. Therefrom, Lordship, this particular notification of 2017 came into being, Lordship. Originally, it was not there.
So that means you are saying only those who are entitled to pension, family pension under the rules,
Yes,
only they will get compassionate family pension.
Lordship.
Then he will be entitled to compassionate appointment.
Then comes this provision of 140, Lordship. Then Lordship will have.
No, then it's all right. No family pension. But then this scheme cannot replace compassionate family pension, compassionate appointment.
Lord,
Compassionate
that
appointment
is the
has no
decision of-
requirement of eligibility under the family pension rules.
No, it is also not that every person who died in harness, his legal heirs are going to get compassionate
No,
appointment.
but they were
Not
entitled to
necessarily.
apply.
Now, there also, Lordship, certain conditions apply.
Yes, but they were entitled to apply.
Yes.
There is no criteria that the person who died must be eligible to receive pension. Then only he can apply.
But my submission will be, Lordship, these are being exceptions, be it compassionate family pension, be it compassionate appointment. These are exceptions to the rules. So government has the authority to fix certain criteria, Lordship. And those criteria are to be fulfilled very strictly. That is my understanding, Lordship, and that is the law also.
Thus, you have to challenge this.
Which one?
You have to challenge this, otherwise it will be difficult.
And in this regard only, Lordship, I will just read one
This
paragraph, Lordship.
You want to challenge or not, you decide.
No, this clarification brought in by my learned friend.
Have you read this? Have
Yes.
you read this
Yes,
notification?
2018. 31st October.
Have you read it?
Yes, my lord.
What is there in it?
Your lordship is referring to page 3.
He is saying this, the proviso says it is only a compassionate family pension can be given only to people who are covered under the family pension rules of 1969.
No, very
Prima facie, that projection may be there. And unless it is challenged, it cannot even be read.
In my
read up.
humble submission, my lord, the description of the scheme that your lordship has given short while ago is the correct description of the scheme.
So you are not, you don't think there is any need to challenge this? That's your final
Yes,
view.
my lord, my case is squarely under the scheme. The scheme has got two parts.
But they have clarified the scheme itself.
No, family pension for cases covering death of government servant while in service appointed on or after 1/2/2005. Lordship is referring to this only. Family pension on provisional basis to the family of the state government employees.
This is according to me, this is a bundle of conflict and contradiction.
Exactly, my lord. Because
After
lordship, I kindly appreciate-
2005, there is no question of pension.
Lord, my learned brother is referring to, my lord, pension. I may not be entitled to pension, my lord. NPS benefit, I may not be entitled. That is totally a separate thing altogether. This scheme has got two parts. First, compassionate family pension in lieu of compassionate appointment. It goes up to the date of retirement. After that, my lord, the family pension scheme or rule that come into play to regulate the family pension benefit. Retirement after the age of retirement. This clarification or this office memorandum has no role to play here. And one more thing, the interpretation given by my learned brother or the respondents that I am not entitled to compassionate family pension, even after my regularization, amounts to treating me a temporary employee or fixed pay employee after my regularization. If the arguments of the respondents is accepted, it will amount that I am till today, I am a fixed pay servant. My entire regularization, which has been done in the year 2018, has been sought to be wiped away by virtue of this argument. Lord, had I not been regularized in 2018 by granting me regular pay scale, then it would have been a different ballgame altogether.
All right, that we have discussed. Yes, let him finish.
Yes.
Lordship, new pension scheme came in the year 2005, Lordship. This compassionate family pension in 2017. Even those persons in between, Lordship, 2005 to 2017, they are getting family pension in spite of they are being covered by the new pension scheme. Let me clarify that, Lordship. They are getting, their husbands, their employees were covered by the new pension scheme, but the wives are getting family pension as per the old pension scheme. That is the provisional benefits given by the government, Lordship. Now here in this case, Lordship, my friend is regularly used the word regularization. Lordship, I have mentioned initially his appointment was as a junior assistant. Subsequent appointment is section assistant. So where is the continuation, Lordship? If Lordship comes to the first representation placed by the wife of the petitioner, Lordship, that is at page 59. Page 59 of the writ petition, Lordship. Lordship, kindly see, with reference to the subject above, I would like to state that my husband, late Manik Chandra Roy, was appointed as section assistant by the appointment letter number 9 and memo number so-and-so dated 26/7/2018.
Mr. Nayak, we are not going to interpret this scheme based
No,
on
I am not interpreting.
understanding of the.
There is no mention about the temporary service,
All right,
Lordship.
yes.
Second,
How have you appointed the deceased husband of the petitioner
Lordship.
in a regular pay scale as section assistant in Water Resources Department on the basis of which selection, which recruitment? That is the question the court is asking again and again. You are unable to say.
But
The
Lordship,
only selection that happened
yes,
was in 2011.
Lordship.
So it is a continuation of that service which has landed him in the water resources. Earlier, the department was what? Transport department or
Transport.
something. Then you shifted him. So all you did is, if one can take that view, that you illegally denied him the pay scale then. You withheld it till this stage, whereas you were supposed to give him then only.
Lordship,
So,
in
viewed
the
from that
advertisement, Lordship, no pay scale has been mentioned. No post has been mentioned. Lordship, this is the department, these are the number of vacancies,
And you
not
saw
there.
how
This is the scale, not mentioned there.
PSC, who has held this?
Lordship,
Because
one
the special
council is,
recruitment drive by the BTC authorities.
So your BTC council selection board has already held it.
yes.
So without a post, without anything, why did you advertise? Why did you?
On fixed pay basis, Lordship, there it has been clearly
Then why
mentioned.
have you asked the fixed pay basis people to apply? In
Because,
the advertisement, you
Lordship.
have asked people working on fixed pay to apply.
Yes, and in the same advertisement, it has been clarified, there is no regular post in the secretariat.
That is why they have been asked to apply.
Yes,
The people working on fixed pay basis in the secretariat, they have been asked to advised to apply because there is no regular vacancy in the secretariat.
yes.
Meaning thereby that if you are also looking for regular employment, please apply here.
But this was an advertisement for the secretariat itself.
You are trying to take advantage of some complete lack of understanding of some of your officers.
Lordship.
They have done things which are mutually contradictory. If you are not having vacancies, why have you advertised? Why have you invited applications from people including
Lordship,
fixed pay employees?
the requirement is that, Lordship, even for fixed pay employee, Lordship, these days advertisement is absolute mandatory, Lordship. Without an advertisement, no appointments
If
can.
you have recruited him on fixed pay basis, how have you absorbed him on regular pay scale in water resources? Is it a mistake?
No, that is what Lordship I am trying to show, Lordship. Lordship, if Lordship comes to the notification for his appointment, Lordship, two notifications are mentioned, 2/6/2018.
That is section assistant and
Yes,
junior
but Lordship,
assistant.
in this notification, Lordship, in terms of which, this is a decision of the Executive Council, Lordship, PTC. Therein, it was clearly mentioned that these posts are going to be filled up by following the provisions of FRBM Act. That was not followed, Lordship. I cannot make submission at this stage on those. One person is already, he is not there, Lordship. What submission I am going to make, Lordship, against him?
And he was the only person who was recruited. There were
No,
other
some other
persons.
persons are there also.
What happened to them?
7, 8. They are
Cancelled their appointment.
continuing, Lordship.
Have you cancelled their appointment?
No.
Then?
No, that is why, Lordship, neither I am making any statement, neither we have conducted any inquiry. Even Lordship comes to his first recruitment, Lordship. Lordship will not get the signature of the appointing authority. This is an appointment letter without any signature. That is how things happen, Lordship.
We don't know who is.
No, Lordship, I am not going to those points. There is no use of going to those, Lordship.
Functioning
But
of
Lordship,
government,
yeah.
everything is not hunky-dory. There are
Yes.
many things which you may also find difficult to explain. We know that.
Lordship.
Because now sitting in the courtroom, post-mortem, looking at this, that is easy. But what happened 10 years, 15 years back, for a council to defend every bit of it may not be possible. But substantively, you have to succeed in showing to the court that this whole idea behind this scheme was only to extend the benefit of people having more than 1 year of continuous regular service. That
Lordship, if-
word regular you should.
Lordship, if I read this judgment of 2008, Lordship, probably it will be possible for me to convey, Lordship. 2008 15 SCC 380 of TDS.
Yes, sir.
Pilot is an against option.
Book list.
One copy was.
Have you given this citation earlier?
On last date, Lordship, I found this. That was the next one.
Is it there? I don't think so. Check it.
Ekon video knowledge, duta paragraph, only 2 paragraphs, Lordship. Paragraph 38 and 39, Lordship. This has been black.
Yes, but then it's not going to help you. This is about a pension scheme.
Family pension.
Yes. All right. So I think you have made your point.
Lordship.
Anything more to add? Don't.
No,
repeat it.
nothing more, my lord,
Right.
nothing more.
Mr. HK Das,
Lord,
Manik,
two
sir.
judgments, if your lordship require.
Huh.
One is in the context of Article 14, it's a recent judgment. I'll write the para numbers. Lordship will kindly go through it. And one judgment wherein this, what is this continuous service? What is the meaning of it? That has been described in one paragraph, my lord. Only these two.
Continuous service is not in dispute.
No, that's what.
Since 28th of
Exactly. my lord.
February 2011,
Yes.
the deceased husband of the petitioner was in continuous service till his
And-
demise.
And,
He
and-
died on 7/12, is it?
Yes, ma'am.
7/12/2018.
Yes.
Till that day, he was in continuous service, is not in denial.
Yes, ma'am. 18/12, yes, ma'am, 7/12 to 2018, yes. and one word the respondents are rigorously searching is that where is that aspect of regularization? The respondents are trying to convey that it was not a regularization, it was on the last day submission was made that it was a fresh appointment, all those things. In fact, in the order itself, if page 48, down below copy 2, down below under the copy 2, serial number 11, serial number 11, Sri so and so, so and so, so and so, so and so, they are directed to report the respective office of so and so issued. Otherwise, the appointment regularization made will automatically be treated as cancelled.
No, this is okay. This is
Exactly.
26/7/2018.
Yes, this was the order by which I was given a pay scale. So the respondents were saying that it was a fresh appointment. First of all, there was no recruitment to process to demonstrate that it was a fresh appointment. My contention is that it was a regularization by granting regular pay scale. So here the word regularization has been used specifically. So once I am regularized, my lord, nothing else come into play. The judgment that has sought to be relied on by the respondents, that is also, my lord, not applicable because in those.
For the petition
my-
also heard Mr. P. Nair, Leonard, additional AG, Finance, Packet Law, State of Assam and Standing Council BTC appearing for the respondents. Arguments concluded, judgment reserved.
Much of
Lordship.
Your job is over. 30 people now, huh? You can go around. We have to take our brain.
the most painful part.